Commissioner. Good morning, all. Today is Wednesday, August 6, 2025. The Zoning and Planning meeting will convene. If we could rise for the pledge, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. If everybody could still stand, we have a moment of silence. Alan Brook left his footprint on Lee County, especially as president and CEO of Marin Group. He passed away May 5th and joined the celebration of life at South Seas last Saturday, where he achieved his life. He's most proud of his business and his business partner, Bob Taylor, the philosophy of the environment, the friendly development, the advocating for lower density and sustainable growth. Please keep in mind when you attend the Lee County Board of County Commissioners and zoning the comprehensive plan that you keep him in your thoughts. Moment of silence. Thank you all. Be seated.
Chairman, thank you for doing that for Alan. And on that note, actually, I'd like to make a motion that we move case 00051 first of the case, the South Seas Island Resort. That'd be my motion.
I'll second that.
Okay.
Motion a second on the floor. Any public comment about moving our third case to first? Anyone have any public comment against that? Okay, I'm going to close public comment, bring it back up to the dais. There's a motion on the floor. There's a second. Any other discussion? Any opposition? Motion passes unanimously. Please introduce us into the case. Thank you.
Good morning, Mr. Chairman, Commissioners. I'm Adam Mendez. I'm a principal planner with the Community Development Zoning Section. First case before you is in reference to South Seas Island Resort MPD, case DCI 2023-00051. The property is generally located north of Captiva Drive in the Captiva Island Community Plan area. The property consists of approximately 120.5 acres in both the outlying suburban and wetlands future land use categories. The property is currently zoned residential multifamily, RM2, green commercial, CM, and two-family conservation district. The request before you is to rezone the subject property to the mixed-use plan development district to permit a maximum of 193 dwelling units or timeshare units, a maximum of 435 hotel rooms, together with common infrastructure and resort amenities. The hearing examiner's recommendation for this case is approval with conditions, and there are 55 public participants of record. Staff and the applicant are present, available to address any questions the board may have. Thank you.
Any questions at this point?
Adam Mendez, I apologize.
Seeing no questions for you, sir, we'll go to the applicant.
Good morning. Neil Montgomery for the record. It's been a long time getting to you, and the aerial before you is an aerial of Captiva. The area outlined in yellow is the property under consideration today. As Mr. Mendez already said, we're here for a rezoning of 120.5 acres from RM2, which is multifamily, TFC, C2, which is two-family attached, CM, which is commercial marine, to an MPD. This is maybe hard to read, but this is important. Obviously, I don't typically start off with a zoning resolution. But you are going to hear a lot of things about what that document says. A lot of them are not correct. What the document says is that the property was rezoned to RU3 with a density of 3 units an acre and 5 acres of commercial. RU3 was the zoning category under old regulations that permitted hotels, restaurants, and multifamily. It doesn't say 912 units. It does not say that hotel units and dwelling units are the same thing. The regulations in effect at the time that was approved clearly defined dwelling units as your normal understanding of dwelling units, and it did not include hotel rooms. You will hear a lot of people suggest that it says that, but it does not. The Board of County Commissioners, without authorization from the property owner, in 1990 rezoned a portion of the property to commercial marine. That allows public marinas, it allows boat repairs, it allows a variety of uses, including restaurants and other things. So the two zonings that are essentially, or three that are in effect, is the marina zoning, which is open to the public and rather intense, the RM2 multifamily, and the TFC2, which is duplex, two-family attached. Then this thing happened in 2002. You're going to hear a lot about this document. One of the things that you need to know is that this document was never adopted by the Board of County Commissioners. This is a, quote, interpretation under zoning regs made by Mary Gibbs and Tim Jones. There were concerns about the fact that this was done without a public hearing. In fact, CCA filed a suit complaining that it was done without without a public hearing, and that it was illegal. When you all considered the resiliency ordinance, there was a question raised by one of the commissioners to the county attorney's office staff about what happens with this document in light of those changes. And the advice that you were given is that in order to be consistent with the height that everybody else in the county uses, how it's measured, we would have to rezone. This thing cannot be amended because it was never adopted by the board. It was only signed by the staff. However, since 2002, people have been using this, and what you will find is that it has less parking requirements than what we would have to do today. It has less buffering than what we will have to do today. No less environmental protections than what we'll have to do today. So you will see that what we are doing is an improvement over what has been. On page 4 of the hearing examiner's report, she notes that the focus is on the delta between the impact generated by existing approvals and those anticipated from the requested MPD. That's really important. A lot of times when we're here before you, we're going from cows to something. This isn't that situation. We are going from an existing resort to a resort with more conditions. But to have more information on that delta, Alexis Crespo is here to speak to you. Get out of her way.
Good morning, Alexis Crespo, Vice President of Planning with RVI Planning and Landscape Architecture. I'm going to give you about a 10-minute overview of the highlights of the project and the proposed MPD rezone, covering some of the high points of the hearing examiner's recommendation and addressing some of the items heard at public comment. There's 19 experts behind me that provided testimony over the course of 9 days of the hearing examiner process, over the course of 3 months, that are here to answer any more detailed questions you have about the MPD. Starting off with the future land use map and the lead plan, the site, as you can see, is in a mix of the outlying suburban future land use, allowing a density of 3 units per acre, allowing for a mix of residential and non-residential uses, which the MPD is consistent with. You'll note the green are wetland conservation areas. Our request is entirely consistent with the lead plan as well as the future land use map regarding the range of uses. Regarding our density calculation, we have reduced the density from what is permitted under the ADD to 193 dwelling units, down from 272. We are seeking an increase in hotel rooms. This has been calculated based upon the Land Development Code and lead plan density provisions, and we are entirely consistent as outlined in your staff report, as well as the hearing examiner's recommendation. All of the areas under the wetland future land use will be retained as preserve areas and will not be impacted. There is a lot of discussion over the course of the hearing about the Captiva land use pattern. On this slide, you have your lower density residential areas as you enter the island in the yellow, transitioning up to those red areas, which are the commercial core around Andy Rossi Lane. And lastly, and very the South Seas resort property in orange, this is about 30% of the island, and it's always been a distinct part of Captiva, having been developed in the late 60s into the 70s. And this is addressed in your policy 23.2.4. We are in agreement with your staff and hearing examiner that Captiva as a whole is not a low-density residential area, but rather a mix of low-density residential, commercial, and then anchored by South Seas Island Resort at the north end of the island. So a distinctive area that is really a part of the historic development pattern in and of itself. The current zoning map was addressed by your staff as well as Neil. The property, in addition to the administrative interpretation, does have existing entitlements. It is zoned largely multifamily or RM2. There's also TFC2. And very importantly, there's the commercial marina zoning district applied to a portion of the property, that northern marina area of the site, that allows for fully accessible public marina uses. It's a very intensive zoning district, and based upon the rules of your manatee protection plans, this site is afforded up to 620 boat slips currently today under that combination of zoning as well as your manatee protection plan. So again, not insignificant current entitlements attached to this property. When coupled with zoning and then the administrative interpretation, currently there's an allowance for 272 units that are a mix of, or have been a mix of hotel, multifamily, timeshare. There's currently also 5 acres of publicly accessible commercial uses at the south end of the property. This is where Doc Ford's had their restaurant. This is where the historic conference center was. So again, currently publicly accessible uses allowed, and then that commercial marina with up to 620 boat slips. That is what is attached to the property today in terms of entitlements. Neil also noted that the proposed MPD is an enhancement over the existing site development regulations outlined in the administrative interpretation. This document allows 50% reduction to the current code parking requirements. This document allows no minimum required open space within the project. This document allows for very permissive internal setbacks and allowance for no internal buffering between uses based on those setbacks. So again, very flexible and very much below the current code standards based on this entitlement. Touching briefly on the redevelopment areas, this aerial is slightly out of date as the golf course is fully redeveloped at this point and looks much greener than on this aerial, but there's really 2 historic areas of development on this site that you're likely familiar with. There's the southern cluster when you enter the property, and then there is the northern cluster where the former hotel site was, and a lot of those resort recreation uses are, as well as the golf course. It is very important to note the proposed redevelopment under this MPD will occur within these historically impacted areas. No new areas that are under conservation, preservation. Existing mangroves will be impacted by the proposal. We're simply going into areas historically used for resort uses and redeveloping those resort uses in a resilient, sustainable manner based on current codes and standards. Adam presented you with the master concept plan. Again, the clusters of development are the south and north, and they're a mix of the residential in yellow, where we'll have multifamily units. The resort recreation areas are shown in purple, and hotel are shown in the orange. What's important to note about this is under our MPD request, we are not allocating all the uses to one area and densifying or intensifying one portion of the site. We are spreading out the condo units between 2 areas, one in the north, one in the south. We are spreading those hotel units to a hotel in the southern area and one in the north. So there's not going to be a critical mass of the proposed entitlements in one area of the site, but it will be dispersed as was the historical development pattern on the site. Compatibility, obviously a key point in this case. We can't emphasize enough the transient nature of South Seas Resort as a whole. This table tabulates all of the existing developments not under ownership by the applicant. These are areas within South Seas not owned by Timbers. And I just want to draw your attention to the very transient nature. This is not a low-density residential community. This is a resort community where many of the buildings are over 90% within the rental pool. So these units are being rented out with a minimum stay of 1 night, much like any type of hotel room. If you visit the property and you walk down the corridors of some of these existing condos, You will note the key cards where you're entering these units just like you would any hotel room. When I've stayed on the property for conferences, I've stayed in the tennis villas for one evening stay. So highly transient in nature as documented through our materials. The longest duration is actually in the timeshare units of 7 days is the longest minimum duration stay within the resort. Just to give you a snapshot of our proposed 45-foot tall buildings in relation to those existing buildings, many of which exceed the height limitations within Captiva as well as the administrative interpretation. We wanted to show some cross sections of these redevelopment areas in relation to existing buildings within the project. So we're first looking at this South Resort area. This is a view in 2022. You can see there's the tennis facility complex around the tennis villa site, employee housing, 140 employee housing units were historically in this location. And then you had the conference center as well as retail, restaurant, and resort recreational uses in this area. This is another view of the existing tennis complex as well as the tennis villas, and then the Bayside villas off to your right. This is a 60-unit condominium. It's a 4-story building. This is built higher than, as documented through survey data provided in the applications, higher than the maximum height allowed by the Captiva plan as well as the administrative interpretation. 75% of the units within this building are in the rental program, allowing one-night stays. And this is our proposed building. In this case, our proposed building is going to have to start at the minimum FEMA AE flood zone standard in order to meet current regulations. And it is about 9 feet taller than the tennis villas building, which would be the closest abutting building, as you can see, about 57 feet away. And so I would propose to you that a differential of 9 feet with this building being brought up to current flood standards to be more resilient, more hurricane resistant, is very compatible with that existing development pattern of multi-story condominiums. Looking at a snapshot of the north, this is going to highlight the proposed areas of the north structure. Again, this area was also developed as an intense cluster of resort uses. Historically, this is where the 107-unit South Seas Hotel was located, as well as you can see the marina where there is active commercial marina operations, such as the Lady Chadwick, bringing day visitors into the site, as well as you can see other timeshare and condominium uses in this area. This is just another view. And then here is our proposed North Hotel. This one, the most stringent or highest floor is based on what is called the limb wall. We have experts to describe to you why that first finished floor is going to be set at that baseline. But it ranges across the site, but we wanted to show you the worst case scenario here. So this is our 45-foot tall building built to the required state and federal flood standards in relationship to the South Sea Club. Fortunately, that is 155 feet away from the proposed building, and you can see the difference in building height is about 22 feet in this case. I would submit to you your compatibility definition in the LEED plan does not state that buildings have to be the same as each other. They have to generally relate to each other in a manner that does not negatively impact each other, and I would submit based on this 2-scale drawing that these will be compatible and consistent with the historic development pattern of the community. Touching briefly on infrastructure, traffic, and safety, our application satisfies all the requirements of your code and LEED plan related to provisions of infrastructure and services. We've obtained all the appropriate letters of availability, and these have been reviewed by your staff as well as the hearing examiner. Something very critical when we eliminate the commercial marina component of this project and the publicly accessible commercial components and make this a resort project, we are reducing the traffic compared to the current entitlements under our conventional zoning districts with the administrative interpretation. Under the current entitlements, our PM peak hour trips are at 346 because of those marina slips open to the public as well as the commercial open to the public. And I will note also, this is a very conservative estimate. You'll note that we base this on 250 slips. We are allowed up to 620 slips, so this number could be much higher. We wanted to be conservative. It would be hard to fit that with building height limitations and shoreline limitations, possible but difficult. So we are showing a very conservative estimate of the current PM peak hour trip at 346 units. Under our proposal, with the 435 hotel rooms and 193 dwelling units, we are at 275. So a net reduction of intensity from a traffic standpoint. South Seas and the current property owner take emergency management very seriously. They have a preparedness plan that's updated annually in place. Sean Farrell is here, who's the general manager, who can talk through any level of detail about how they effectuate this plan when tropical storms and named storms are within striking distance of the resort. Very important to note, Irma, you can see 0 people, including guests and staff, were on this property based on their emergency management plan and the procedures they take once a tropical storm warning is in place and once a hurricane warning is in place. So they have operated this property for many years, as Sean has as the GM, with a high success rate. Ian, also, no guests or staff were on the property at landfall. So the plan is in place and clearly working based on the cluster of storms we've had. Before I close out, I don't think we could underscore enough the positive economic impact to Lee County that redevelopment of this resort will effectuate. This is the largest resort in Lee County. This is a wonderful attractant to bring people to the area to really fall in love with what we have to offer here in Lee County. And you can see the numbers on this screen of the increased property tax base of $653 million, annual property tax revenues to the county of $2.4 million, other property tax revenues totaling $9.3 million annually, and then a very substantial increase in your tourist tax revenue, which I would submit is something Lee County needs for its recovery efforts after a rough couple of years. So to conclude, your staff, your hearing examiner have recommended approval of this zoning request. They have assigned 20 conditions to the property. These conditions are an enhancement to the existing entitlements under the conventional zoning and the administrative interpretation. We are decreasing the commercial intensity by eliminating the publicly accessible marina and the publicly accessible commercial at the entrance. We are decreasing trips. We are increasing building setbacks. We are substantially increasing on-site parking by meeting your code requirements and providing additional amenity parking per the conditions and deviations. We are increasing landscape buffering. We have incorporated new conditions related to outdoor entertainment consumption on premise, which was not regulated at all under the administrative interpretation. We are effectuating time limitations and different performance standards to increase compatibility with people outside of the MPD within the resort. And also of note, we have team members here who can speak to additional and really important conditions related to environmental enhancements, increased standards for turtle lighting that go well above and beyond your code, water quality monitoring, natural resource monitoring. So again, this MPD is adding in much more stringent regulations than currently exist in exchange for additional hotel room units and the decrease in multifamily. We are in agreement with all of the conditions and would respectfully request your approval of the MPD today. Again, there's 19 experts behind me who can answer any questions you may have about the case. Thank you.
Any questions? For the
No,
applicant?
none at this time.
Well, thank you. Go to public comment. I will start with public comment. I have 55 participants that are listed that testified, obviously, before the hearing examiner. The first one's John Agnew. You have 3 minutes to speak. The green light will go on. The yellow light will give you a minute indication. The red light will indicate that you should wrap up your sentence.
Yes, sir, thank you. Good morning, Mr. Chair, Commissioners. My name is John Agnew, and I'm the City Attorney for the City of Sanibel. My wife, Suzanne Boy, and I are also residents of the City of Sanibel. In the HEX proceeding, detailed comments were provided by several representatives of the city, including all of our elected officials, including Mayor Mike Miller, Vice Mayor Holly Smith, council members Richard Johnson, John Henshaw, and Laura DeBruce, as well as City Manager Dana Souza and our Deputy Police Chief, Dr. Anthony Thompson, and myself. The testimony provided by these city representatives indicates just how important and impactful the development increase permitted by this requested rezoning of South Seas Island Resort would be to the city, given that Sanibel is the adjacent community through which all evacuees and travelers from South Seas must travel. As you know, Sanibel and Captiva are fragile barrier islands that have been repeatedly devastated by recent hurricanes. The state land planning laws within Chapter 163 Florida statutes recognize the importance of intergovernmental cooperation. And one of the reasons it exists is to ensure that the land use decisions by one local government do not adversely impact adjacent nearby governments. Without a doubt, an approval of this rezoning application would adversely impact Sanibel, the adjacent local government. The proposed increased density and intensity of use and associated traffic impacts would negatively impact an already constrained and overburdened evacuation route and generally adversely impact already untenable in-season traffic on island. These negative impacts affect Sanibel's citizens, the community at large, the quality of a visitor destination, and the city government by placing additional demands on the city's public safety officers and staff. We ask that you acknowledge these adverse effects and so many others that you will hear summarized by the speakers that follow by recognizing the long-standing 912-unit development limits on South Seas and reject this rezoning application. For the remainder of my time, given my position as the first speaker, I'd like to, and my familiarity with procedural due process and quasi-judicial proceedings, I'd like to focus on what I would encourage you to provide in the way of speaker time for the remaining public speakers, consistent with Florida law. At the hearing examiner proceeding, several individuals spoke not only on their own behalf, but they spoke as formally authorized representatives for others. We ask that those representative speakers be not only able to speak up to 3 minutes on their own behalf, but up to 3 minutes on behalf of those individuals for whom names are on the record below as they were representing. This includes, without limitation, attorneys Michael Bell and Katie Berkey, who represent multiple timeshare entities and community associations within South Seas, and Lisa Rorden, who was the authorized representative of 84 persons before the hearing examiner and whose signed and notarized authorizations were submitted to the hearing examiner at the HEX hearing. Lee County's administrative code contemplates the commission allowing more than 3 minutes of time per individual speaker at its discretion. We ask that you use that discretion to allow that additional speaker time for certain additional speakers, being mindful that the extensive public impact of and interest in the decision and the procedural due process rights of those who spoke directly before the hearing examiner or who were authorized to do so on others' behalf. With this in mind, what we ask is that the following individuals in alphabetical order have additional time. Michael Bell, 24 minutes, Katie Berkey, 10 minutes, James Evans, 10 minutes, Richard Grosso, 20 minutes, Zach Libetro, 5 minutes, David Mintz, 10 minutes, Jerry Murphy, 10 minutes, and Lisa Rorden, 10 minutes. Thank you.
Thank you. Please, County Attorney.
Yes, sir. The County Attorney's Office has heard these requests and have identified, as Mr. Agnew indicated, that it is up to your discretion to allow the additional time. The board has allowed additional time in the past. Typically, it's when individuals represent multiple parties or people. The board allows for additional time. We do not have any objection to the times that were just listed.
Okay. What's the board's pleasure?
Just for clarity, I would love to ask, so they're saying the lawyer is going to speak on behalf of or in place of the actual participant who spoke at the hearing then, as their representative? And the only other question I have then is typically when I presided over cases like this as the chair, we have denied people who were not actual attorneys from speaking for others before. So like, I don't know, forgive me, Ms. Reardon, are you an attorney as well? Or, because Michael, I think we've talked about that before. We would let attorneys stand in for people, but we weren't letting other citizens stand in for other citizens.
Here's where the code comes into different play here. the way the participants are defined, that before the hearing examiner, Mrs. Reardon, if she has written authorization from the individuals, can show up and be their authorized representative.
Okay.
If she does not have written authorization from everyone, she cannot. I think I just heard that she actually submitted that.
She does, okay, all right. Well,
What-
that's-
What that doesn't allow her to do in this proceeding before the board, only before, in the board's chambers, legal counsel can participate and represent participants. So she would not be able to stand up here and represent the participants, but legal counsel can. But it's a little bit squirrely how our code is set up. So she can create the participants at the HEX hearing, but our code does not allow her to represent them in this proceeding. But with that said, we're still okay with the 10 minutes.
I'm okay hearing any of it. Hopefully, it's this competent substantial evidence. We're sitting in a quadjudicial setting, so hopefully these participants that are going to speak, or the ones who represent it, will provide maybe some competent substantial evidence. If not, maybe they'll repeat what they've said before to me in my recorded meetings with our county attorney present. So I'm looking forward to seeing if they are truly transparent of what the reason why we're sitting here for today. Thank you.
Yeah, I don't have any objections, Mr. Chairman.
Commissioner Greenwell? Commissioner, you with us?
Yes, can you hear me?
Yes. So you heard from the county attorney, you heard from Commissioner Pendergrass, Commissioner Hammond. I certainly don't have any objections. I just wanted your opinion on the record, please.
I don't have any objections.
Okay, okay. So we'll proceed, obviously, in the manner. I think it's important if you come up with competent, substantial evidence, keep your comments as direct as you can. Try to respect the fact that there's a lot of people that want to testify, and whatever brevity you can achieve with being precise would be appreciated.
Chairman, if I could, just for I know there's some different times that the attorney had spoke of different times. You know, the attorney's got 20 minutes, and some other people between the husband and wife, they got so many minutes. Is our timekeepers going to be able to keep track of the times between who gets what? Some got 10 minutes, some got 20, some got 5. I'm not
so
sure.
maybe for clarity purposes, when the speaker comes up, indicate who you are and what designate was indicated you that for minutes, and we'll certainly record it from there. Does that sound okay?
And it's also, I can say for the record that all these speakers had unlimited time doing the hearing examiner
Sure.
process. Some had probably took hours to do their presentations, and the evidence before us is here that was heard at that hearing with all the evidence, and they had unlimited time there. So they had opportunity then to provide any credible, substantial information the day of the hearing.
So I believe if you come up and you indicate what you did at the hearing examiner's time, what type of time you spent, you indicate for the record who you are, and then indicate exactly the time that you're looking to have allotted. We'll certainly time from there. Again, with that in mind, you will have a green light, a yellow light, and a red light. When the yellow light goes on, you have a minute to wrap up. Anyone that could be as concise as you can be would be greatly appreciated. Second speaker in mine is Audrey Albrecht. Say that right, last name? Audrey here? I don't see anybody from that. Jeffrey Alexander? And we can come back to any speaker that I missed that isn't here. Jeffrey Alexander. No Jeffrey. Joe Barbary?
Excuse me, Commissioner, but I'd like to see y'all spend less money on air conditioning and more money on sound. The people in here cannot hear what's going on.
Try to speak up louder, sir.
I'm sorry, sir?
I said, well, try to speak up louder.
Okay. Oh. My first question to you is, I got a couple of questions to y'all. Has any of y'all read the transcript of the hearings? Anybody read the total transcript?
Sir, this isn't a question and answer period. You're just
Well,
giving
okay.
your testimony.
Well, it's a rhetorical question.
I understand. Just trying to state the facts here.
The other is, what we don't understand is, why y'all joined into a lawsuit that they initiated, that every attorney in Lee County laughed about and said that they were going to lose. Now, to the...
Object, this is outside the scope of the record. We have to address mistakes of fact or law on the record.
Okay. Thank you, Nell. Appreciate it.
You're welcome.
Now, as you all know, the purpose of government is to protect the health, safety, and welfare of the community. And Captiva and Sanibel is not Coney Island, it's not Busch Gardens, and it's not Disney World, and we don't want it turned into that. They're installing a water park within hearing distance of my home, and it's going to create a noise that is irritable. They asked for 20 deviations. 20, not 1, 2, 3, or 4, but 20 deviations. Talked about the sewer in the middle of a mangrove swamp that is already inadequate, according to TKW Engineering and Dr. David Tomonsky from a 93 report, I think was the date on it. Talking about hooking up sewer to Sanibel. To my knowledge, there's been no agreement about hooking to the sewer in Sanibel that Sanibel has agreed to or what have you. We know, and there's been testimony, there'll be increased pollution from the road traffic. And most of your pollution on Sanibel and Captiva is coming from the road traffic, according to the engineers. Sign pollution. They want huge signs up there. And every community in the country is trying to get rid of huge signs and sign pollution. Their engineer talked about breakaway walls. That's fine. What he didn't tell you is where, when the walls break away, where they're going to go. Now, my neighbor, pool table. Any of you ever play pool or know how much a pool table weighs? Well, it wound up under my house. My neighbor's pool table did at the last hurricane. Oh, by the way, my understanding is if you're a good pool shot, that it's a sign of wasted youth.
Point of order, Chairman, it looks like the time is.
Yeah,
Right, okay.
your time has come up. Unfortunately, the red light's on, sir.
Do I have a minute left or something?
Your red light means you have to stop.
I'm sorry?
The red light means you have to stop talking. The yellow light gave you the warning.
Oh,
Your testimony is concluded. Sorry, sir.
well.
Michael Bell,
Thank you.
Esquire. You're welcome.
Commissioners, if I could ask that the PowerPoint be brought down, if possible.
And how many minutes
This is,
Okay, I'll do that momentarily. Would take the,
Someone steals.
huh?
Yeah,
So-
time,
24 minutes.
how many?
No, I don't have anything. I just wanted it down, so just for focus. purposes.
Do you know which icon is yours?
Yep, no, I don't need anything up. I just wanted it down.
Okay.
Sir, just for the record, state your name again and how many minutes that you're allotted, so it's clear on the record.
Commissioners, my name is Michael Bell. I have allotted 24 minutes, and I would ask if any of my remaining time be left over for Richard Grasso. Everything that I'm going to say today was presented at the HEX hearing. There's no additional information I'm providing, the part of the report or what I was, what I presented Again, my name is Michael Bell. I'm an attorney that focuses my practice on real estate and association matters. I represent 8 timeshare associations located within the South Seas Resort Development, the SSRD, which is established by the Lee County Zoning Resolution Z73702, subsequent county actions, and it was memorialized in the Administrative Interpretation ADD 2002-00098. I'm speaking on behalf of those 8 associations, and I also spoke on behalf of, I believe, constitutes 63 other individuals. I was not requesting time for them. With respect to the South Seas Island Report, the MPD DC 12023-00051, and the pending rezoning applications, the associations that I represent and my firm represents are more than 6,000 individual fee simple title owners. Property owners within the South Seas Resort, some of whom have owned their property for more than 40 years. I could reiterate if the commission wants, but to save time, all the different associations, there are 8 associations and 63 individuals. They were part of the HEX meeting, and all of those names were reiterated and the information was put into the HEX hearing. So for saving time purposes, I don't want to reiterate all those names and association names. That was also part of my Composite Exhibit 1, which was known as Bell Composite Exhibit Number 1, which again contained all the individuals in the 8 associations. This is a huge and very complex case that's been ongoing since 1973, where all 20 condo and HOA associations that are part of South Seas oppose the applicant's rezone. As I told you, I represent 8 associations and 63 individuals. During the HEX hearing, I submitted, and documents were accepted as public exhibit number 1. There's no issue with regards to the people I represent and the association I represent. The resort was designed as a PUD cluster development concept using the open space of the entire resort to justify the clustering of units in excess of 3 units per acre. That's an extremely important piece. The Administrative Interpretation 2002-00098, which pretty much you'll hear it referred to as the ADD, which the applicant consistently relies upon for what they refer to as their vested rights, has a process for modifying the South Seas Resort PUD. The applicant purchased the property understanding that the property was subject to the ADD. That's also very important. Public records research shows that the applicant contacted the county to amend the PUD pursuant to the ADD, but was directed not to follow the ADD, but rather file a separate rezone application. No public hearings were held about this to confirm this change after 50 years. No court confirmed the change. No county commission hearing took place to give notice to the property owners. And the property owners who have owned for decades relying honestly on the county commission and the ADD and the mediated settlement, which you've heard much about, which capped the building permits at 912. No one was ever contacted. The change was made and the process was started. The purpose of the administrative interpretation, which is stated in the ADD, was to summarize and clarify all prior approvals into one comprehensive document detailing what development currently exists, clarifying what additional development may be permitted, and provide for a reasonable method for the county to review requests for future development. It's also very important, development approvals, to modify or change the master development plan adopted by the resolution Z73202. As a result of the ADD, thousands and thousands of my clients, fee simple property owners within South Seas Resorts, received a vested right to be involved with any change to the PUD to extract land that has existed within the PUD for over 50 years. What's happening here is we're pulling out land from one PUD and creating 2 PUDs. The original PUD in 1973 and subsequent development approvals relied upon the open total development resort space and the shared amenities as outlined in the ADD. This ADD approved the development with the following conditions. Current and future development within the SSRD will be limited to a development density of 912, utilizing a small-scale cluster development, which means that you may have had a parcel over here, which is less than so many acres, but you're allowed to put more than 3 units per acre on that spot. Be carefully planned and tightly controlled. Provide for a self-supported capability in terms of facilities and services needed. Emphasize pedestrian movement. Preserve shoreline and mangrove areas, including 2.5 miles of beach, 3.5 miles of bayou shoreline, and 20 acres of plantation preserved mangrove forest. It was also supposed to demonstrate leadership and rational development techniques in advance of proposed or enacted legislation. And here's the kicker. Provide and maintain a balance of dwelling units, amenities, and service facilities for the benefit of the entire community, all SSP owners, and guests of Captiva and Lee County. That was supposed to be the open area at the front. That's what was provided for. This means the development was conditioned upon that the community could access amenities and service facilities, which is exactly opposite from what the applicant is attempting to do. The ADD required the treating of South Seas Resort development similar to a PUD. It was a PUD concept in 1973, in accordance with Article 6, Division 10, Subdivision 4 of the LDC, which is the Land Development Code. As my clients own property within South Seas Resorts, they have a vested rights, as confirmed in the administrative interpretation. My clients have consistently requested aggrieved party status at the HECS, and we do so again today. In support, I would argue that the applicant shows the entire pool area as an area to be rezoned to allow service of alcohol pursuant to a COP. The area to be encompassed by the COP license partially involves land not owned by the applicant, but rather owned by my clients. The cottages who appear at the HECS, I appeared on their behalf. This inclusion of land not owned by the applicant adversely affects my client's due process rights. Based upon this alone, this matter must be tabled and the application amended and resubmitted. Even if the applicant argues that the land to be rezoned around the north pool only involves land owned by the applicant, the remaining land around the pool owned by my clients cannot be dissected from the land to be granted a COP license, and as a result, the application cannot proceed. At the top of the hearing, the HECS hearing on February 14th, Richard Grosso, counsel for the Captiva Civic Association, asked for aggrieved and adversely affected party status and an opportunity to submit the written request for same into the record. The hearing officer stated that the request for the indicated party status was denied for anyone but the applicant and staff. I also raised the assertion that my clients were entitled to aggrieved and affected party status, and advised the hearing officer that my ability to assert the association's interest had been compromised by not being able to provide party status at the start of the HECS proceedings, and as a result, being denied the opportunity to make a full presentation with the opportunity to cross-examine county staff and the applicant and the opportunity to provide rebuttal and closing testimony. I submitted for the record my request for aggrieved and affected party status at all public hearings in this case and on my client's behalf, and the hearing officer accepted that request, but denied our party status. The request was also originally transmitted to the county attorney's office with copies to pertinent county staff and the applicant on February 11th, 2025. Florida Statute Section 163.3215, entitled Aggrieved and Adversely Affected Party Status, articulates the manner in which the state of Florida protects adversely affected parties in land use hearings, such as this exact case. In Florida Statute Section 163.3215, the term aggrieved or adversely affected party means any person or local government, as in Sanibel and Captiva, that will suffer an adverse effect to an interest protected or furthered by the local government comprehensive plan, including interests related to health and safety, police and fire protection services, densities, and intensities of development. For example, water parks, transportation facilities, equipment or services, and environmental and natural resources greater in degree to the general interest of the public at large. The associations I represent clearly fall into the parties to be protected by Section 163.3215, and I would again request aggrieved and adversely affected party status. The 2002 ADD limits development to 912 total hotel and residential units and up to 5 acres of commercial on the south end, which was supposed to be open to the public. The 2003 settlement agreement, to which Lee County was a party, also limits current and future development of dwelling units and hotel rooms to the historical limit of 912, and was recently held by the Circuit Court here in Lee County to be valid and binding. The conditions and development standards within the ADD, in conjunction with the 912 unit cap under the ADD, and further, memorialized again in the 2003 settlement agreement between the county and the Captiva Civic Association, was intended to prevent and mitigate adverse impacts to the incompatibilities within the surrounding areas. The applicants claim that certain deviations incorporated into the ADD related to open space, parking, and buffering are vested for a new application seeking to substantially increase building heights, density, intensity is legally flawed. and foreseeably results in adverse impacts and incompatibilities, which the ADD was intended specifically to protect against. The applicant cannot have it both ways, have the right to expand, and then have a non-conforming use. The applicant is a minority owner of about 120 acres. I'm not talking about total acreage. I'm talking about we have more than 6,000 fee simple unit owners out there in South Seas. They're one unit owner. They do own 120 acres, but they are small with regards to the total number of owners. Within the SSRD, which is subject to the rezoning application, but the remainder of the total 304 acres, again, is owned by others who are within the SSRD and are subject to the ADD, which we have not consented to and have not joined in on this application. The applicant's request for rezoning effectively destroys the PUD concept, which was what was designed in 1973, for which all fee simple property owners bought into, and have relied upon for 50 years, and creates two PUDs. You got an NPD now and an old ADD PUD, leaving the original PUD as an orphan, without sufficient land to protect any argument of non-conforming status, nor the ability to meet the requirements of the original PUD concept. If you look at what was required in the original PUD, it is impossible to be met. The original PUD was designed as an open space cluster development concept. The exclusion of the current land to be rezoned destroys the original PUD concept and will leave the remaining parcels as non-conforming if they were required to build. What I'm talking about, we have a 2-acre parcel with a condominium on it that has 10 units. They'd only be entitled to 6 units to rebuild. How's that going to work? This cannot be, again, understated. Parcels were developed based upon the total open space of the entire development. If buildings require redevelopment, say after a storm, they could only be done based upon the land. The resort was sold to the applicant with full disclosure that Mariner Corporation had previously advised all owners via a formal, written, and transmitted letter as far back as 2004 that the resort was completed except for 24 units. That's what they've sent out to everybody. The applicant purchased the property with full knowledge of the 2003 mediated settlement between the owner and Lee County. For almost 50 years, owners of real property within the resort have relied upon the prior resort owners' statements and the signed agreements by Lee County that the resort was constructed as completed. At no time did any prior owner of the applicant's property purchase with the understanding that the resort property would contain any more than 912 units. In fact, as a reminder, the prior owner downzoned the property from over 3,000, excuse me, and Mariner actually stated and published to all the resort owners that they'd completed it all but 24. The circuit court here in Lee County has very recently granted summary judgment against Lee County and the applicant, with the court finding that 912 units is the maximum number of building permits that can be issued by Lee County.
I'm going to interpose an objection.
This is my time. If she wants to, I want to accept the objection, but this is my time, and I object to her interrupting my time.
We'll pause your time, but.
The hearing examiner advised that the zoning hearing was not about.
Excuse me, this is based on the testimony that I made.
And I objected at the zoning hearing, and I continue to object to bring.
The objection was noted.
Into the zoning.
The objection was noted, commissioners, and we were allowed to proceed to present the evidence. So at the time, pursuant to the rules, I'm allowed to present the evidence that I presented at the Hex hearing. As I stated at the beginning of my presentation, I'm only presenting the same information. And I acknowledge Neil's, Ms. Montgomery, objection, but we're still entitled to present the information. And all I'd ask is for any objection to be raised at the end so I can finish I'd like to recap any time that I've lost as a result of that. Again, the circuit court here in Lee County has very recently granted summary judgment against Lee County and the applicant, with the court finding that 912 units is the maximum number of building permits that can be issued by Lee County within the resort, and the applicant is bound by the 2003 mediated settlement. Based upon that ruling, there's no reason to rezone the property. Both the county and the applicant have appealed this ruling. A stay of this rezone should be issued by the county commission on all the applicant's proceedings until the appellate court has ruled on the recent circuit court summary judgment ruling capping building permits at 912, including hotel units. This will prevent conflicting orders, which would require the county commission to reverse its decisions. Another reason for denial of the applicant is the access road for which the applicant seeks rezoning is not solely owned by the applicant, and the additional owners have not been joined into this application, which prevents approval. The ownership and rights of the access road, which others partially own and control, and who are not co-applicants and are outside of the proposed MPD boundaries and the wetlands future use land designation, are already dealing with safety issues, operational performance, and worsening road conditions, maintenance, and costs. Therefore, the association and their associated members should have been seen as indispensable and required to join any rezoning application. The applicant and the association share an access roadway and easements, the entire extent to which is not within the proposed MPB. That's really important. It's not fully owned or controlled by the applicant. The applicant improperly attempts to use a historically 30-foot wide ingress and egress and parking easement, which was established in 1960s, mid-60s, before any of this ever happened, as a landscape buffer for the rebuilt restaurant located westerly of the only access road within the resort. The easement recorded in the 60s benefits all the property owners within Section 22 to allow for the ingress and egress and vehicular parking for access to the beach. The county cannot burden the easement holders' rights by requiring the applicant use the foregoing easement for a landscape buffer or anything else, or any other burden. If the county requires a landscape buffer for this requirement, it should be implemented north of the easement area on land owned by the applicant. There is current litigation pending with the applicant, and the county regarded the easement area, and the county regarding the easement area and the use of the easement as a landscape buffer and overburdening the easement with utilities or utility boxes. The ADD constitutes a comprehensive planned unit development to be developed as a unified 304 acres. The individual property owners within the SSRD relied upon this and the master plan's binding commitments regarding the maximum number of units, the open space, and the quality of life which has existed for 50 years. It should be noted that the applicant has loosely used the term guest when talking at the HEX hearing. The applicant is some helpful owner for all of the amenities they have. The applicant's made a concerted effort to deny the longstanding owners within the resort access to parking, restaurant facilities, and other amenities within the resort. All three timeshares with amenity agreements with the applicant are currently in litigation, as the applicant is denying timeshare owners access to amenities in violation of established amenity agreements. So when the applicant talks about guests having amazing amenities, they're not referring to the current resort owners. Most of them are being denied access to amenities. And some of the most owners that are being denied access, and most of the owners are being denied access to some or all of the amenities. The applicant's argument that there will be an all-encompassing resort to reduce traffic is 100% false. If most of these owners are now going to be denied access to amenities, where are they going to go? They're going to leave the resort. So the whole concept of the fact that there's going to reduce traffic, they're now going to drive off, because we used to have restaurants that everybody could access. All of those have been closed. Now they're going to have to drive off the resort, and that's going to increase traffic. Excuse me. In fact, isn't it ironic that the trolley that is supposed to reduce traffic is really a trolley to nowhere for most of these resort owners, further necessitating the need to add vehicles to the overtaxed roads already on Captiva. All of these restaurants now will only be accessed by people with a resort amenity agreement with the resort. Most of the people who now own out there will not have access to any of the amenities on the resort. They're going to be leaving the resort. So all of those owners that are now saying, oh, we're going to be on the trolley, that isn't going to happen, because the trolley just goes to the gate. Now they're going to hop in their cars and drive to all the restaurants on Captiva and Sanibel. So guess what traffic's going to do? It's going to go up. So when there's an accident, because we don't have any sidewalks on Captiva, for all the bikes and people walking, they're going to look back to the vote with regards to how did this all happen? How did all this traffic happen? The applicant is not entitled to the rezoning being sought, and the requested deviations are indefensible. The application has and will continue to procure benefits and development prospects within the remaining 272 total vested units pursuant to the mediated settlement of 2003, which would now include dwelling and hotel units, and with 24 unbuilt units pursuant to the ADD. The 8 associations representing over 6,000 individual fee simple property owners, as well as the 63 individuals that I have requested to speak on behalf of at the HEX remain firmly opposed to the application as submitted and are in full agreement with my arguments in the fact of not approving the rezoning application and believe that it violates the LEED plan, the Land Development Code, and must be denied for the following reasons. The rezone application increases density and building heights in violation of the LEED plan, as well as the mediated settlement. The rezone application must be denied as it violates the understandings regarding density, building heights, open space, and property rights that the majority of the owners of South Seas relied upon for many decades. The rezoning application will increase evacuation times on the one road in and out of Captiva. That is incontrovertible. In the case of a hurricane or other natural disaster, and threatens public safety on both Captiva and Sanibel. If evacuees cannot get off the island and suffer harm, it can be related to this application, and for that reason alone, it should be denied. The rezone application will increase development at the expense of the environment, including water quality and wildlife habitat. Approval of the proposed rezoning will further worsen traffic and overburden the already narrow access road that has no bike lane and no sidewalk. The application removes the public 5-acre commercial area that resort owners have relied upon to not have to leave the resort. Without this public facility, resort owners with no amenity access will be forced to leave the resort in contradiction of the applicant's statements, and this will increase pedestrian and vehicular traffic and potentially contact with vehicles for serious accident and death. The rezoning application will also increase traffic on both Captiva and Sanibel for residents, guests, and others to levels beyond burdensome. The rezone application will increase density and building heights, will undermine the low density and low building height ambience that makes Captiva a unique, worldwide sought-after designation. The residents of South Seas Island Resort have always flocked to the island due to the quaint, family-friendly feel it emits. Why destroy what has been created at South Seas Resorts? The traffic study as contained in the staff report, page 327, says that there is a South Seas airport shuttle and that the service will reduce traffic impact. Both the general manager of the resort and the applicant's hurricane evacuation expert have testified that South Seas does not have an airport shuttle service, a clear and important falsehood. The policies of the LEED plan do not permit approval of the rezone application. Furthermore, the applicant was advised in writing upon purchasing his 120 acres of the 304-acre resort, the resort was vested for a maximum of 912 dwelling units, including 140 housing units for employees and 107 hotel units. It wasn't until the applicant spoke to the county that a plan not to follow the ADD modification process was designed. And this change of not following the ADD was never vetted by a court or this particular commission. It's based upon the foregoing and on behalf of the 8 associations and the 63 individuals that I represented at the HEX that I would request that the application be denied. Thank you very much. Any remaining time, I'd like to move to Mr. Grosso.
Thank you for your time.
Just for the record, was there any time left from Bill?
34 seconds.
Okay.
Katie Berkeley? Okay, if you could just state your name and the time allotment for the record. Thank you.
Certainly. Good morning. For the record, Katie Berkey, Land Use Attorney at Becker and Polyakoff, and I'm here today as legal counsel to the 12 associations listed on the PowerPoint. For clarification in the record, this is my PowerPoint that was presented before the HEX and accepted as Berkey Exhibit 2. The only change is titling the exhibit in the upper right-hand corner. Otherwise, it's the same.
How much time?
How much
minutes?
Yes, reflecting the acceptance made to allow me 10 minutes on behalf of my 12 association clients.
10 minutes.
And any unused time I ask be ceded to Richard Grosso, counsel for CCA.
Just so the board knows, the objections that we don't concede time and let people start adding up time. They've asked for time. We've agreed to the time frames that they've asked for, not this, we're going to keep adding up more time for.
Like a running clock for billing reasons,
Right.
whatever. Yeah.
The protocol in the room has always been that we don't acquiesce or transfer time that's remaining to another person. We've never done that.
Okay.
So whatever time you have, you utilize. The prior speaker had a minute and a half left over. I don't transfer that to anybody.
Thank
That's
you.
just
And
the
if I could
protocol.
have, 20 seconds back for the
Yeah, no problem.
remark. I
I'll
would-
give you some latitude.
Thank you.
No problem.
So for background, all of my association clients are within the 500-foot notice radius for the rezoning application before you today. All of them are located within the South Seas Resort Development, or SSRD, as established by the 1973 zoning resolution, subsequent county actions, and memorialized further in the 2002 administrative interpretation. And each, as Attorney Michael Bell already indicated too, have investment-backed expectations in reliance on the commitments made of the existing entitlements across the combined 304 total acre SSRD, again guided by a planned unit development, or PUD, plan. Further, the applicant and the association share the internal access roadway and easements, the entire extent of which is not within the proposed MPD boundary. You'll see they're circled in red, and which is not fully owned or controlled by the applicant. Particularly at the south end, we're shown in red, where the applicant only holds an easement interest, but the road is within the condominium properties of Beach Cottages, Beach Villas 3, Gulf Beach Villas, South Seas Plantation Beach Home, and Sunset Beach Villas. However, the entirety of the road, including the portions not owned by the applicant, is subject to deviation numbers 2 and 14, as reflected in the HEX recommendation, as to internal right-of-way buffers and road standards, respectively, without the consent and joinder of these outside owners. This contravenes Lee Plan Property Rights Element and LDC, Section 34-202 Sub A, providing that the applicant must submit he is the owner or authorized representative of the property subject to the request, and that he has the full authority to secure the approval required and to impose covenants and restrictions on that property. The applicant is not the owner of the full extent of the road, nor the properties along the road which have existing vegetation to serve as the alternative roadway buffer, nor is the applicant the authorized representative of those owners. Given the historical, current, and future interconnectedness and reliance on the shared access road and easements, along with being immediately adjacent to and intertwined with the property to be rezoned, the associations and their respective members will be detrimentally affected and suffer special damages if the rezoning is approved. For example, the loss of views and privacy, unreasonable overburdening upon ownership and longstanding easement rights in violation of the LDC and the Lee Plan, traffic on already constrained roads and corresponding roadway maintenance costs at a level far in excess of what has been endured by the association and their members historically or currently, and adverse impacts to their vested rights. In recognition of these considerations, I respectfully request that my correspondence transmitted 2 days prior to today's hearing on or about 7:30 a.m. on Monday the 4th for the Commissioner's benefit through county staff and the County Attorney's Office with a copy to counsel for the applicant, consistent with the guidance given on the meeting agenda for today, be accepted into the record. I was subsequently advised by the Deputy County Attorney that this transmission would not be presented to you all in advance of today's hearing, which further exacerbates the limitations on speaking time today. However, this transmission is not new evidence. It simply reiterates our prior request for aggrieved and affected party status made February 11th, more than 48 hours prior to the HEX hearing, and to document my client's continued objection to being denied party status. The original request, as I mentioned, February 11th, it was transmitted to county staff with a copy to the County Attorney's Office and counsel for the applicant more than 48 hours prior to the HEX proceedings, and was the subject of my testimony before the HEX, noted in volume 3 of the transcript, pages 3 through 33. And the original request was accepted into the HEX record and identified as Berkey Composite Exhibit 1. And it's also referenced in Exhibit C to the HEX recommendation at page 4. I have hard copies of that transmission from earlier this week, which again is a August 4th cover letter to restate our original request and continue to object if we're denied. And I also have Mr. Jacobs' email advising that it wouldn't be shared with you in advance of the hearing for context. So I respectively request it be accepted into the record, but if not accepted into the record for consideration, I ask that it be made part of the record as a proffer by my clients for appellate purposes.
So she's made a request to have a transmission entered into the record. I guess we could see what our county attorney thinks about that.
We have no objection for her handing it into the record.
Yeah,
Doesn't change anything, but she can hand it in.
okay.
Thank you. If you could pause my time so I can just distribute. I also have copies of my PowerPoint in hard copy, which again is already in the record if anyone would like it.
She's right here.
It was presented at the hearing before, though?
Thank you, thank you.
It was already presented at the hearing?
Yes.
Okay.
All right, thank you. To briefly conclude, well, and actually, to piggyback on Attorney Michael Bell's testimony, this was a direct quote from the report, which is an exhibit to our aggrieved party letter from February 11th. The applicant is requesting many substandard variations and in some cases complete exceptions. These variations to the minimum standards combined with the increase in vehicular, bicycle, and pedestrian traffic will likely increase the probability of crashes, worsening the safety and operations of the roadway. Without alternative designs or mitigating measures for these substandard conditions, there is an increased risk of worse operational performance and safety. Drew Rourke, a PE and traffic expert. And to briefly summarize, the applicant is not entitled to the rezoning being sought today. They've derived ample benefits from the site flexibility to date and the cap of 912. The access road serving the development is recognized as constrained in the applicant's own testimony, and the entire project is constrained due to surrounding long-standing existing development and its long linear nature. Accordingly, the applicant should simply abstain from further development. But if approved, the associations and their members will be inordinately burdened by the application made without their consent and joinder as co-owners of the road and as easement holders, and as being owners within the SSRD subject to the guiding PUD plan. And the road, again, is subject to deviations on property that the applicant doesn't own and without my folks' consent, making it not ripe for approval. Accordingly, we respectfully request that you deny the application outright, or if instead it's your pleasure, remand it back for a complete application to be made with the consent and joinder of all indispensable parties. Thank you.
May I ask just one question for clarification? I know we don't do questions and answers, so I promise I won't make a habit of this, but like the folks that you represent, you're talking about, they're condo owners?
Condos and HOAs, yes,
Okay.
community associations.
And are they full-time residents, or are they people who rent these condos out as like Airbnbs and use them similar to hotel rooms?
Some rent, some are there full-time. I couldn't tell you the percentage breakdown, but it doesn't diminish them as owners or easement holders of the road in particular. And how they use their unit doesn't mean that their voices should count any less before you.
Okay, thank you.
Thank you. Any other questions?
Thank you.
All right, thank you.
Next person is James Berg. James Berg. Dennis Berry. Dennis? Malcolm Briggs. Malcolm Briggs? Rebecca Briggs. Jay Brown. Marianne Cowell. Marianne? Laura DeBruce. Matt DePaulis. Matt. Evan Dupont. James Evans.
Good morning, Chairman Ruane, members of the commission. I am James Evans. I'm the CEO of the Sanibel Captiva Conservation Foundation. I testified at the hearing for the zoning hearing for approximately 1 hour, requesting 10 minutes today for my presentation. I should be able to complete that well in advance of that 10-minute time frame.
Granted.
Thank you.
10 minutes.
So SECF is a science-based nonprofit organization located on Sanibel Island. We were founded in 1967 to protect the unique barrier island resources of Sanibel and Captiva Islands. I'm here today to oppose the rezoning for the South Seas Island Resort Mixed-Use Plan Development. The FGUA plant does not have the capacity to treat the volume of wastewater that will be generated by the proposed rezoning of the resort. The rezoning and the MPD violate Code Section 34-202, Sub A, Sub 10, which requires a letter from FGUA verifying its ability to provide service to the proposed development. The availability letters of May 23rd, 2023 and January 23rd, 2025 do not verify FGUA's capacity to process the 187,457 gallons per day of wastewater produced by the proposed mixed-use development per DCI 2023-00052. The hearing examiner found that the MPD will receive sanitary sewer service from the FGUA, Florida Governmental Utility Authority, but she did not find that the FGUA facility had the capacity to serve the additional amount of development the rezoning would allow. There is no competent substantial evidence that the facility has such capacity. The lack of available sewer capacity at the FGUA plant for the proposed rezoning and MPD was demonstrated by my unrebutted expert testimony and evidence of. As I explained at the hearing, the FGUA letters of availability dated May 23rd, 2023 and January 23rd, 2025, staff report R and applicant PowerPoint slide 190 reveal that the available sewer capacity at the FGUA plant is inadequate to meet the wastewater demand reflected in the applicant's sewer demand analysis on page 524 of the staff report. The FGUA plant's design capacity is 264,000 gallons per day. FGUA's 2015 capacity analysis report stated its capacity was reduced to 222,300 gallons per day when operating in a conventional activated sludge mode, and its highest permitted capacity is 264,000 gallons per day. That is not enough capacity to meet the proposed MPD's sewer demand of 187,457 gallons per day, which leaves only 76,543 gallons per day for the existing 640 units outside of the MPD, less than 120 gallons per day per unit, almost all of which are multifamily or multi-bedroom units. FGUA's estimates of 117,880 gallons per day available capacity for the MPD, including associated facilities, referenced in its January 23rd, 2025 letter, can be compared to the capacity outlined in the 2015 capacity analysis report, wherein calculations show that it had 109,500 gallons per day. Total available capacity for the existing 107 units and 142 bedroom multifamily units the applicant's predecessor was planning for the 120 acres. Current conservative estimates of the capacity required for the 435 hotel rooms and 193 multifamily units total 144,900 gallons per day, rather than the applicant's estimate of 126,000 gallons per day, without the 6 restaurants, 78 boat dock slips, and water park, which the applicant estimates at 61,257 gallons per day. But the capacity is not there for either the applicant's MPD estimate of, but the capacity is not there for the applicant's MPD estimate of 187,457 gallons per day, or the more realistic number of 209,000. He is not there for the applicant's MPD estimate of 187,457 457 gallons per day, or the more realistic number of 209,900 sewer overflows of approximately 60,100 gallons in potential violation of Chapter 4-3, Florida Statutes and Rules 62-620 and 62-604, Florida Administrative Code, which prohibits unauthorized discharges. A list of the various violations was provided during the zoning hearing, and I provided that to the hearing examiner. The record demonstrates that the FGUA plant struggles to handle the current volume of wastewater, let alone significant increases in volume by adding substantially more guests to the resort. The wastewater treatment plant currently does not treat to advanced wastewater treatment standards. The reuse water that is distributed as irrigation to the golf courses and landscape to support the resort is likely to contribute to additional cumulative impacts to our coastal water quality, water bodies that are already impaired by the state of Florida and are on the state 303D list of impaired waters. If this zoning is approved, it will further impair the coastal and estuarine waters and resources of Lee County, likely contributing to the decline of Lee County's coastal ecosystems, such as seagrass beds and organisms that depend on these important ecosystems. Based on plant capacity, the level of treatment, combined with the underlying geology, sandy soils, and relatively low elevation on the barrier islands subject to tidal pumping of nutrients into the groundwater adjacent to coastal waters, the applicant has not demonstrated that they will meet the surrounding water quality standards. And I won't read all of the sections of the code where it's inconsistent with the goals, objectives, and policies of the Lee Plan, but that was all in my testimony. But we firmly believe that this property, if it is rezoned to allow the increase in density and intensity of use, it will have significant impacts on our natural resources, including water quality, wildlife, and the coastal resources of Lee County. We want the South Seas Island Resort to be successful. It just can't be at the expense of our natural resources, our residents, and existing businesses. I want to thank you for the opportunity to provide comments to you today. Thank you.
Thank you. Leo Farrencroft? Leo? Okay. Bill Finley? Marilyn Frederick? John Chagas? Richard Grasso?
Thank you, Mr. Mayor, Mr. Chair, members of the commission. My name is Richard Grosso. I'm an attorney for Captiva Civic Association. I've been deeply involved in this matter and been a land use lawyer for about 40 years in the state. I had sent a letter requesting that I get 20 minutes. I've got a lot of things. I really pride myself on trying to be really helpful with my comments. I would ask that I have 20 minutes if I can. Thank you very much.
Yes, sir.
I'd like a 5-minute recess then, Mr. Chair, before we start that one.
Sure. Let's have a 5-minute recess and we'll start back up.
Okay, thanks.
The request of the commissioner. We'll just have you start now, sir.
20 minutes for the timekeeper.
You're recognized, yes.
Thank you, sir. Richard Grosso again on behalf of Captiva Civic Association. A quick housekeeping thing, as was the case with Ms. Berkey, I would like to have introduced into the record what I've identified as Grosso 1, 1A, and 2, which was the correspondence that on behalf of CCA I had sent early Monday morning to try to preserve the record, to bring all the issues to your attention, and to preserve our request for party status. If I could have those documents entered into the record. I've got a copy for everybody that I can hand out when I'm done, if that's okay.
Duly noted.
Thank you, sir. You know, the HECS process where we were denied party status, you know, your rules in all candor may or may not comport with full due process requirements. It's a difficult thing, right? The applicant gets to present a case and put witnesses on and direct their testimony, and then gets to cross-examine opponents in real time. You know, we don't get to do that. The opponents don't get to do that. And you know, that has an impact in the real world of making findings of fact that limitation where it's kind of an uneven playing field really is a real world problem, and we're very concerned about that impacted the findings. Nevertheless, the findings of fact that have been presented to you, the issues have been presented to you by the HEC's recommendation, clearly support denial. I'll make a quick legal point. Under Florida law, even if a rezoning could be argued to comply with a comprehensive plan, the Board of County Commissioners, this is Florida Supreme Court, has the right to make a policy decision to say, you know what, the existing zoning also complies with the comp plan. That's all you're entitled to for whatever legitimate policy reasons. We're going to deny an increase, and that's what we clearly think you should do in this case. The Captiva Community Plan went through a lot of effort and was put into your comprehensive plan as official binding law several years ago. It was specifically put into the Lee Plan to prevent this. If words like maintain, enforce, historic development patterns in keeping with historic development patterns, limit development, protect existing land use patterns, maintain historic low-density residential development pattern. And remember, at that time, low-density residential meant residential and hotels, because the 1973 rezoning decision, the application to that clearly was about hotels and residential units combined for the maximum of 912. That is clear. Your ADD confirmed that, made that very clear. Your ADD, by the way, was adopted into the code. It said they're exempt from certain things only to the extent they comply with the ADD. So it did have legally binding effect, and it was the document, along with the 73 rezoning, that for 50 years guided all development out here. For 50 years, people made investment decisions of the parcels and the units they bought based on that. The community plan was absolute. If it didn't mean don't increase density, intensity, why was it put into the plan? It's meaningless if this rezoning is to be approved. The big support document for that explains what was happening. This is in the record. It said when we adopt the community plan, heights are also limited in keeping with Captiva's low-rise buildings. Captiva issues warrant more stringent regulations. The goal is put into the plan. It says that this is low-impact development is our current pattern that should be maintained and supported into the future. It says the purpose here is to limit rezoning approvals to those which do not increase density. And again, at the time, density applied to both hotels and residential units. That's clear. That's been the historic development pattern here. It said this goal is to have limits on residents and visitors who need to evacuate. That's a vital. Visitors too, and residents. And it said the purpose of what we're adopting here is to control density and intensity. So you want to call hotels intensity, that's fine. It covers both. Control them to that which currently exists. That was the intent of the community plan. That's why it was put into the Lee plan. But yet here we are with a request to substantially increase the number of units. Now, I also understand there's an argument that, well, the residential units are often used for vacation rentals and they're akin to hotel units. You know, which is it? If residential units are the same as hotel units, according to the applicant, then there are numbers where we're reducing the residential units and replacing them with hotels, so that's a decrease in impact. Well, then, you know, that can't be true. Both of those things can't be true. The reality is this is a substantial increase in the number of overall units there. That number of overall units by zoning decisions, ADDs, constant stream of official county actions has been 912. That was the thing. The code has a provision, and I'll get to it in a minute, section 34.612. 2H. And remember, the 1973 rezoning, as it's been explained over the years by your staff to you, was the new precursor for the PD, the planned development process. In exchange for a reduction of zoning, the applicant got this previously unprecedented amount of flexibility for site design and lot size and all that stuff. Your code says the purpose and intent of the planned development districts is to provide a process and record on which developers, public officials, the general public, and consumers of development may rely. Consumers of development. So my clients and the clients of others that have come before you, people that have made their investments in reliance on the 73 rezoning, the major 912 cap that was clear, reinforced for years, those people under your code have a property right to rely on that. But yet here we are, after buying a piece of earth, buying a piece of land that had 912 development rights, or at least their share of it, knowing that that was the deal, and now say we want more. And this isn't a rezoning of just some open piece of land and you're making a brand new policy decision, we're changing our mind about what we ought to do with it. This is completely built out, save for maybe 25 units. And having reaped all the benefit of that and sold off most of the lots to other people, now somehow, as if you could realistically, physically extract that 120 acres from the rest, treat us like we're different. And the arguments have been we're walled off from everybody else in Captiva, you know, people won't notice. I mean, that's just, that's not reality. You can't just physically extract this piece of earth after everything that's been built there, all the investment that's relied on it, all of the shared infrastructure, the garbage collection and stormwater and the roads and the easements and the amenities. This was developed as a unified whole master plan development. That's how it's always been. That's how people have made investment decisions. And now the idea we can extract the 120 acres, we bought what we bought, that's all they're entitled to under Florida law, but now they're asking, frankly, for a windfall, but then other folks who had the benefit of a certain density and open space in certain locations and all that, they lose the benefit that they thought they were getting when they made their investments. That's the fundamental problem. This code section says people ought to be able to rely on that. That means meaningless if this is approved, if this amount of increased density is improved. That's a real problem. You know, the HEX findings they give you certain facts and your decision is based on those, but clearly this board has the policy discretion to interpret its plan and apply the facts to the plan. Fundamentally, section 34.413 of your code governs both density and intensity, so it doesn't matter whether you want to call hotels residential or commercial. And it says very, very clearly, there's density and intensity decided on a case-by-case basis in accordance with a number of factors that it's your authority to weigh and balance. One is the range of density or use is permitted or encouraged under the LEED plan at that location. There can't be much question that the range and density and intensity of uses and encouraged by the LEED plan at that location have constantly been 3 units an acre, certain height limits, 912 at South Seas Island Resort. There can hardly be, I think, a reasonable argument other than that. It's at this location, and I think that the application, and with due respect, I think some of the aspects of the HEX report talk about, like there's one example, the height differential isn't a compatibility problem, there's a finding, because height differentials are commonplace in Lee County. But this isn't just anywhere in Lee County. This is Captiva, subject to much more stringent regulations through the Captiva Community Plan, one of them being the height thing, which has always been a major component of the historic development pattern. And so it's this location. I think the premise of the application, and maybe as has been they persuaded the HEX recommendation, was that we do this in other places, but the emphasis in the code on rezoning decisions is about what's appropriate at this location. It's a very site-specific, very fact-specific thing. I think you know where we stand on that. I think you know where the majority of people stand, where the facts stand on that. One of the other factors to base the rezoning decision is public safety. Now, certainly there was arguments below that we'll get everybody out in time. It's a hotel, so people will stop coming or they'll leave early and that kind of thing. And I think the hearing examiner was persuaded, apparently by testimony, confidence expressed by the expert for the developer that, well, we'll get everybody out. We've had a pretty good run of luck here of getting hotel guests out before everyone else had to leave. it's this commission's responsibility, it's your staff's responsibility, it's law enforcement's responsibility, emergency managers, to understand that the world's changing. For whatever reason, the dynamics that are impacting hurricanes and their intensity and how quickly they change and how much storm surge we're going to get, that is changing. So the idea that we'll rely on past history and just assume we're going to keep getting that lucky for every storm that ever comes after we've approved this amount of increased development on the tip of Captiva Island, the farthest away from safety, that's a weighty policy decision to make. And I think that obviously we believe that responsibility, putting public safety first, particularly when the private property rights of the applicant have been exercised. They've got what they bought, they knew what they bought. Private property rights of other folks are kind of at risk here because of what they bought. They're fixing to be in a position to not get anymore in terms of the ambiance and the quality of life and all that. And their ability to safely evacuate. That's a huge problem, and I think a lot of folks are very concerned that we're here with this request with people still fixing their homes after Ian and Milton and Helene, and how you could be asked to make a policy decision to gratuitously increase density in this location, given the realities of what's come before and the tragedy of loss of life and the causeway being wiped out, and put ourselves in the future and look back. Wow, why did we do that? Why did we increase development on the tip of Captiva Island after what this community had been through all those years? That is something we think should weigh heavily on your mind, because it's a criteria in your code, but it's obviously also an important responsibility for anyone who has the position that you all have earned to be on this board. And the other criteria is the nature and the density and intensity of existing development surrounding the project. That's the other factor to base a rezoning decision on. And again, you've heard the history. You know what that history of existing density and intensity of development surrounding this project has been. That's not really a matter of debate. Those are clear facts. So through 50 years of regulation under that section, which is the key section that governs a rezoning decision, we think it's an easy decision to keep us at the existing 912. That's what the community plan was all about. And what do those words mean? Words matter. Not to be all lawyery on you, but when planners and lawyers write language into a comprehensive plan, that where's the comma go? What word do we use? No, let's use a different word. That matters. And so just to pretend the community plan wasn't there and those words don't exist to enforce existing land use patterns and historical development pattern, what does that language mean if something like this, massive rezoning like this, is approvable? And then on the question of density, there is a hearing examiner report. First of all, maximum densities under any comprehensive plan, and certainly yours, your plan says this very clearly, maximum densities are maximums. They're not entitlements, and what actually is the right density to be approved on zoning decisions is based on the case-by-case factors that I just got done discussing with you. So to be clear, maximum density is not an entitlement. But the maximum density in this outlying suburban land use category is 3 units per acre. And about 12 years ago, there was a hearing examiner report on a similar kind of rezoning request. And staff pointed out to the hearing examiner back then, hey, our code has an exemption for hotel units are exempt from the residential density limits. And the hearing officer in that case, and it's in the materials that I've submitted, said, actually, yes, that the code says that, but policy 1.1.6 in the plan doesn't support that distinction. It doesn't make that distinction. It doesn't say the code can exempt hotels from residential density. And it's a clear point of Florida law that the plan trumps. The comprehensive plan is the overarching governing document. Any code provision that's inconsistent with the plan, not supported by the plan, is irrelevant, cannot be enforced. The plan is the dominant document that has to be enforced. And so this density then violates 3 units per acre. It violates policy 1.16, the comprehensive plan, unless one wants to say we can exempt hotel units from that. But is that the reality? Is there a reality here that a hotel unit doesn't have the same amount of impact as a residential unit? The same applicant that's going on about how people with residential homes, they rent them out. You know, some are doing that, I guess, till they retire, and then they're going to permanently live here. But the reality is that they're the same. Their impact is the same. In fact, when people are coming to hotel units to play, they're out and about a lot more often. They're having a greater impact. And so we question strongly whether there's any validity to the idea that we can exempt hotel units from the residential density caps that have been clearly put in place and enforced for 50 years for just this very reason on Captiva Island. That's troubling. That's a fundamental problem of density and intensity. Again, this isn't everywhere else in the county. You know, the community plan provisions are in the plan because these particular places, and this is good planning, the one-size-fits-all rules, I think most people who care about like smart land use planning and property rights and that kind of thing, that's not what you do. You have rules that are specific to that particular place. Why make everybody live by really, really stringent restrictions when really we only need those stringent restrictions on this place or that place? That's what you've done with your comprehensive plan, but yet I think the application wants you to act like this is anywhere in the county. Outlines are ruined, max of 3 units per acre, and we exempt hotels because we do that other places. Well, it's not another place. It's Captiva. We've never done that before. So that we've never done that before, but we're going to do it now, that's not the historic development pattern. That's not the existing land use pattern. That's not what people have relied on. That's not what your comprehensive plan requires you to enforce and maintain. So the idea that we could read Chapter 23, enforce, maintain, existing, all those words, and that somehow we could interpret those to mean it's okay to expand and enlarge, that language means nothing if it's okay to expand and enlarge. I think the application, and I believe the HEC's recommendation, just ignores the scope and the size. And that's inconsistent with Florida law. When you read Florida statutes, the definition of when is a development order consistent with a comprehensive plan, it's use, density, intensity, and other aspects of the development. Yet the ruling and the recommendation is, look, it's been a resort. So as long as it's a resort, it doesn't matter if it gets a lot bigger resort than it has been. That's wrong. That is not how land use is done in Florida. It's use. If the statute said if it's the same use, it's consistent. Okay, great, but it doesn't stop there. It's use, density, intensity, and other aspects. So it's a resort, it's still going to be a resort. That doesn't cut it. That violates the statute, that violates your comprehensive plan. We think that the enormity of decision, the clear facts that everyone's known for years, the facts that came out in the HEC's proceeding, clearly require a denial of this. We ask you on behalf of people who have invested their lives in this place for over the last 50 years to please deny this application. I thank you for your time.
Thank you. Next is John Henshaw. Ed Holden.
Hello, my name's Ed Holden, Sanibel resident and licensed professional engineer. I've already testified. Everything these guys say that are going to be problems with this expansion is true from an engineering technical standpoint. In my business, every project of the magnitude of a power plant had offsets. You're going to impact the community. We know it's going to happen. you have to provide as part of your scope of work offsets to help the community. I just want to highlight 4 of them and put a little schedule on them that's going to help mitigate a lot of the problems that this is going to create. We talked about traffic. What we need to start, maybe even this season, is a shuttle system that moves people off the island through Sanibel, pick up the workers that are going to go up and work at South Seas, and then take them home at the end of the day. Easy. It takes the traffic problem down. The traffic is so bad there, the school buses sometimes have to stop so the kids can have a bathroom break so that they can continue to wait in traffic to get home. That's just not right. Let's start a shuttle system this season. The sanitary sewer system, it's not going to work. It's going to need some upgrades. That system, instead of putting it out in leach fields or the way it's designed now, you can do some secondary treatment and make reclaimed water, take that same water that you just received, send it back up there and use it for landscaping. Maybe the whole island. I'm tired of swimming in what percolates out of those septic tanks. It's going into the ocean. We already know that. You can take it another step. You can make it potable water and put it in this fancy cement pond you're building up there as a swimming pool. Employee housing, it needs to come back in. The employees can't afford to make this long trek. Let's get the employee housing back. And you also need a secondary evacuation route. Put in an emergency boat ramp so you can get on and off the island. And let me give you a spoiler alert. You can use it for construction. You can float in all your materials. The bridge closes down at 40 miles an hour in Sanibel, the one that washed away. The next bridge that's going to go out, and it'll probably be the Sanibel side, is the bridge that connects Captiva to Sanibel. Okay, it's going to happen. So plan on that. Give us a ramp, give us an exit path, and more importantly, a way to rebuild by bringing things on there. Thank you.
Thank you. Callie Johnson. Richard Johnson.
Was Richard a 3-minute or a different? Was Richard 3 minutes, like, or is it something else?
I won't take more. I'll be under 3 minutes. Good morning, Commissioners. I think it's still morning. Thank you for the opportunity to visit with you. My name is Richard Johnson. I am a resident of Sanibel, a business owner on Sanibel, and also I sit on the City Council there. So I recognize the challenge that you have before you today, and I appreciate the time that's being spent to study this issue. Earlier on in these proceedings and conversations that we've had and testimony that's been provided, there was a conversation about change and how difficult change was. And I can share with you that my community has gone through significant change in the last 3 years. And yes, it is hard, but we got through it. And we're continuing to move our way through it. We've managed those changes without opposition from our community. We've managed those changes in keeping within the Sanibel plan and the overall scope and feel of our island and our community. The codes. We've done this without changes to density and intensity of use. And we're well on our way to recovery. Secondarily, the applicant, when they made this purchase of this property, was fully aware of the density and intensity of use, the 912 units. I can't imagine that any company, the magnitude of the investment that these folks are making, would not recognize that and be prepared to work within that. Let me say this, I want this organization to be successful. I want the applicant to be successful. I want them to do it within the rules and regulations that we all agree to abide by. Change is hard, and it's not always in the best interest of the residents, the businesses, and the guests that visit Captiva. The other thing I'll mention is doing the right thing is hard also. So please, do the right thing in the best interest of everyone involved and deny this rezoning request. Thank you very much for the time. I appreciate the work that you do.
Thank you. Linda Ladd? Linda? Tony Lappy? Richard Levinson? Zachary Liebert Esquire? Zachary, you here? Great. Again, like all the other speakers, if you could state your name for the record and the time you need.
Okay. Reflecting the agreement reached with the county attorneys, I'm requesting 5 minutes of speaking time. My name is Zachary Liebetru. I'm representing RLR Investments, LLC, and Royal Shell Vacations, Inc. For context, RLR owns and operates several properties on Sanibel and Captiva, including 2 within the South Seas Resort, and dozens of properties within South Seas are also managed by Royal Shell. Preliminary matter, I'm renewing our request for intervener status. We made this request at HEX, and we believe that HEX erred in her decision to deny that request because RLR owns properties within South Seas and also utilizes the shared internal access road. Our concerns are already on the record from HEX. Some things I would like to reiterate are that the internal access road is an easement shared among several of the parties here in opposition today, and the applicant lacks the authority to modify that without all these co-owners' consent. That's also in your LDC and LEA plan. At the HEX hearing, the Royal Shell president testified that Sanibel is known for that laid-back, low-density residential and smaller resorts. That is why people come to this area. That is why the increased traffic from this rezoning will harm the tourism industry. And this is also backed up by the Visit Fort Myers study that I presented at HEX. It says year after year that the #1 concern of visitors visiting our area, particularly the barrier islands, is traffic. It's the #1 concern, greater than insects, hurricane damage after the hurricanes, and during the COVID years, even COVID. So we're all in favor of this economic competition and the new ideas. However, we're merely asking that if the applicant is going to be requesting and the county is going to make a change to the nature of businesses on Captiva, that we all have an opportunity to make sure that it is fair to everyone. So although my client would ultimately like to see this rezoning denied in its current form, should the board approve this rezoning, we would request that the board consider a stay of the effective date of the rezoning ordinance during the pendency of appeals which are currently pending in the 6th DCA. We tried to submit this request to you in advance so you could read it and understand our recommendation, but we received word from the county attorney's office that none of our submittals would be transmitted to you. So instead, I'm just going to go through it here. And I'd like to start by saying I'm making this request on behalf of RLR, Royal Shell, and also the Captiva Civic Association. The request is to grant a conditional motion to stay during the pendency of the active litigation in the 6 DCA cases. These cases are an appeal of the circuit court decision, which saw a final judgment entered enforcing the mediated settlement agreement from 2003 between CCA and Lee County. And in that final judgment, the judge stated that no permits can be issued to exceed this 912 unit cap. And this rezoning, if approved, would violate that final judgment. And so what we want to avoid, and what I believe is in the county's best interest to avoid, is a situation where you approve the rezoning today, the ordinance is issued, the applicant applies for and receives building permits, starts construction, all while those appeals are still pending, and then the CCA wins on appeal, and the final judgment is enforced, meaning that these issued permits, constructed buildings are all unlawful. And there's plenty of case law stating that courts may order the demolition of non-compliant buildings. So approving the rezoning risks the wasteful development if the courts uphold the final judgment. A stay would prevent this irreversible harm while the appeals are resolved, and this sort of temporary delay would ensure clarity from the appellate courts without any significant impact to the applicant's rights. So I'm asking for you to stay the effective date of the rezoning ordinance until the appeals and any judicial review there are complete. So thank you for your consideration, and I have copies of our renewed request for intervener status and the conditional motion to stay that I would like to offer for the record.
Thank you. Next speaker is Robert Locker, PhD. Robert doesn't seem to be here. Lisa Maxwell. Is Lisa here? Eric Milbrandt.
Good afternoon, Commissioners. My name is Eric Milbrandt. 3 minutes is good for me. I'm a research scientist. I've studied water quality here for 22 years. And because of where this development intensity is being applied to be increased on Captiva, the area is essentially a desert of nutrients. And the places, other places in Lee County, like along the Caloosahatchee River, we have a lot of nutrients coming from the watershed and Lake Okeechobee to fuel harmful algal blooms and potentially habitat loss. My concern is the increased nutrients around the north part of Captiva will further degrade habitats such as seagrass and intensify harmful algal blooms like red tide. In the conditions in the HECS report summarizes water quality plan development. I think that would be great, but those need to be expanded to include monthly sampling, and it needs to include ambient water quality throughout the North Captiva area, including areas in the aquatic preserve, which are the environmentally sensitive areas around the resort. So I would like you to consider that in your deliberations. Thank you.
Thank you. Mike Miller.
Good morning, Commissioners. I'm Mike Miller, Mayor of Sanibel, and I'm speaking here today along with many of my neighbors because the decision you're going to make in this application will greatly affect us. The County Land Development Code requires that any change in zoning must comply with the Lee Plan, and Plan Policy 2.2.1 says in part that rezoning should be evaluated as to the availability and proximity of the road network, compatibility with surrounding land uses, and other relevant facts affecting public health, safety, and welfare. Much of the examiner's report deals with the need for resiliency and the related argument in favor of increased building heights. No one disagrees that future buildings should be constructed to withstand the impact of major hurricanes. But building with resilience and increasing density are two very different things. Things done for different purposes and with different consequences. The hearing examiner recognizes this concept when she states on page 4 that her focus, quote, is on the delta between impacts generated by existing approvals and those anticipated from the requested MPD. Her focus is accurate, but what are impacts? For us on Sanibel, the impact will be on traffic congestion. We already have, depending on the time of day and the time of year, considerable traffic. Anything at the margin that exacerbates our congestion will have a huge detrimental impact. And given the geography, increased traffic on Captiva necessarily migrates to Sanibel. Incremental traffic is generated by incremental effective density. Under this application, hotel density will increase from 107 to 435 units. Residential density technically will go from 140 to 193, but the 140 were very low intensity employee housing, while the proposed 193 units will in all likelihood be multi-bedroom condos. So the increase in bedrooms, assuming 2 bedrooms per condo, will be 574 new bedrooms, a 230% increase compared to pre-storm. The idea that this increase will be offset by the termination of public use of the marina and amenities just doesn't hold water. South Seas has usually not been open to the public, and any additional restrictions will not be sufficient to offset the increase in effective density. The net impact of these impacts will make Sanibel's traffic worse and will negatively impact the welfare of those county citizens that live on Sanibel. The recommendation is thus flawed, it's inconsistent with the principles of the lead plan, and therefore the rezoning request should be denied. Thank you.
Thank you. Next speaker is David Mintz.
Good afternoon. My name is David Mintz. I am the president of the Captiva Community Panel. I'm also on the Land Use Committee of the Captiva Civic Association. I believe I've been allocated 10 minutes, and I appreciate that. Thank you very much.
Duly noted.
Commissioners, when you amended the Land Development Code to exempt South Seas from Captiva's density and building height regulations 2 years ago, this all started 2 years ago, we warned you that it would eventually lead to a major increase in density and intensity and a serious violation of the plan. But at the time, and I went and looked back at the tapes, you were told that would not happen. Commissioner Pendergrass, you were told that the action that day does not increase density, and I know you remember that. Commissioner Hammond asked, is it correct at the end of the day, this will still read, referring to the plan, that this would still read and enforce development standards that maintain the historic low-density residential development pattern of Captiva? And the deputy county attorney told you all of that remains the same. The deputy county attorney also told you that density at South Seas will still be at 1 to 3 units per acre. But that's only if you don't count hotels. The deputy county attorney also said that Captiva density is 3 units per acre. Nothing is changing with that. But that's only if you pretend South Seas is not on Captiva. The deputy county attorney also said the hotel cap on Captiva remains the same. That has not been changed.
Mr. Mintz did not go through this long dissertation attacking Michael Jacobs at the text. So this is new evidence which should not be permitted.
I am not attacking Michael Jacob. I am reminding everyone what was told to you, the commissioners, when this all started. And it's in the record.
This is not part of the record.
Actually, I will continue. So the hotel cap on Captiva will remain the same. That has not been changed. That's what you've been told. But that's only if you don't include South Seas. So here we are, commissioners. The South Seas application dramatically increases density and intensity on that resort. We're going from 272 units, which were approved for 50 years, to 628 units, plus the buildings are 20 feet higher than any other building on South Seas or Captiva. We're more than doubling the density on the applicant's 120 acres. We're bringing South Seas units from 912, which existed for 50 years, to 1,268, well over 3 units per acre. And we're putting 435 hotel units on 5 acres of commercial property. That's 87 units an acre. And this sets an incredible precedent for future developers to demand the very same right to build on Captiva in the years to come. So what do? We're just suggesting that you follow the Lee Plan. The Lee Plan requires the county, and Richard Grosso mentioned it clearly, requires this county to limit development to that which is in keeping with the historic development pattern on Captiva. The Lee Plan requires the county to enforce development standards that enforce and maintain the historic low-density residential development pattern of Captiva. The historic development pattern that has to be enforced and maintained is perfectly clear. The 1973 rezoning resolution limited hotels and residential density to 912 units. The 2002 administrative interpretation said current and future development is limited to 912 units. The 2002 compliance agreement, which Lee County signed, required 102 property owners on South Seas to eliminate their lock-off units because it took them over 912 units when they rented them. The 2003 mediated settlement agreement stipulated 912 units are the limit. The county shall not issue any building permits that exceed that number at any time. And every other South Seas regulation limits current and future development on South Seas to 912 units, including hotels. We're talking about a 50-year history of 3 units per acre, 912 units. That's a historic development pattern that hundreds, if not thousands, of South Seas property owners relied on for 50 years. So where do we go from here? I suggest that it's very easy and very straightforward. Just enforce the Lee Plan as it's written. We just need a motion from you, Mr. Commissioners. We just need a motion to remand this application to the hearing examiner for consistency with the historic development pattern of 912 hotel residential dwelling units in the same building heights as the rest of Captiva. Just remand it and ask that it be made, or demand that it be made, consistent with the plan, and we can go from there. Thank you very much.
Thank you. Jerry Murphy.
Good almost afternoon, Commissioners. For the record, I'm Gerald Murphy. I spoke for 45 minutes before the hearing examiner, and I believe I've been allocated 10 minutes. Everything I'm going to say today was stated at the public hearing before the hearing examiner. My involvement with the subject property began over 20 years ago when the Board of County Commissioners of Lee County asked for determination of the status of the Unified Plan of Development for South Seas Resort, approved by the zoning resolution in 1973. Excuse me. Under the direction of the County Attorney's Office, I researched and drafted what's been called the Jones-Murphy Memo and subsequently helped prepare the Administrative Determination ADD 2002-00098, analyzing past, present, and potential future development entitlements for the entirety of the South Seas Resort, and the resort's approximately 304 acres. That includes the subject property that's before you today. Excuse me. What we found, and what's important for this hearing, is that development at South Seas Resort is governed by a 912-unit development cap, set by this board with approval of the 1973 zoning resolution, inclusive of hotel units and residential units, across the entirety of the approximately 304 acres, unified by shared amenities, wetland conservation areas, open space, and parking. In addition to the 1973 zoning resolution, this 912-unit cap is reiterated in subsequent memoranda and administrative approvals and a settlement agreement. The county's intention was to allow creative, flexible site design, a so-called planned unit development, to realize the entire unique unified resort development plan. That was formerly available, as a PUD that was not formally available in 1973, while holding firm to the overall limit of 912 units in a 304-acre resort development with unique unit-based development plan. That is the historic development plan and historic development pattern approved for South Seas Resort. It is crucial to understand that the 5 acres designated for commercial use under the 1973 plan were meant solely to serve residents and resort guests, not to house any additional hotel units above the 912-unit total, or the additional adverse impacts that those additional uses will visit upon the property owners of the rest of the resort, the Captiva community, and the city of Sanibel. If these additional units are approved, it will result in the highest number of resort units within both Captiva and Sanibel Islands, at the farthest point of Lee County's bridged barrier islands. ADD 2002-00098 was not just my determination. It was agreed to by the county and the developer and the other property owners on South Seas Resort, and reinforced in administrative decisions since, including administrative decisions and determinations ADD 2003-00077A, ADD 2004-00077, ADD 2006-00041, ADD 2008-00082, ADD 2014-00203, and ADD 2015-00015. All owners of units within the resort have been aware of this development unit cap of 912, including the applicant, who now seeks to unravel that unified South Seas Resort Development Plan and its limitations. In the past 50 years, hundreds of property owners and Lee County taxpayers have invested in that limited number of units at South Seas Resort in reliance on that 912-unit development cap established in 1973. Since the advent of Hurricane Ian, the county has apparently been assisting in unraveling the South Seas Resort Unified Plan of Development through the adoption of ordinances 23-22 and 23-33 under the guise of addressing the building envelope squeeze brought on by higher first floor elevation performance standards and the Captiva community height limitations. The most egregious of which is Map 18, which purports to describe a, quote, South Seas Island resort, close quote, overlay to remove the resort from the Captiva community, and includes in its purported boundary and legal description references to official record books and strap numbers for 3 parcels of property on the south side of Sandcap Road that have never been part or identified as part of the South Seas Resort. All the focus of this application is on a limited amount of land owned by the applicant, with no consideration for the remaining resort property owners and their vested entitlements. This violates the County Comprehensive Plan, the LEAP Plan, property rights element required by state law. In conclusion, after decades of review, it's my professional opinion that the 912-unit cap governs all future development at South Seas Resort, and there is no reasonable alternative reading in the record. My testimony builds upon firsthand experience reviewing the regulatory documents, direct involvement with the developer, other resort property owners and stakeholders, their attorneys, and other representatives to determine the development entitlements vested by the county. As a Lee County resident, property owner, and taxpayer, I urge you to deny this request and continue to protect the health, safety, and welfare and property rights of the county and its citizens. A well-reasoned, quasi-judicial decision by this board in this matter will consider the inordinate burden this request will visit on the existing property rights of the many other property owners in the resort and the cost of defending the inevitable legal actions that ensue from ignoring the citizens' existing property rights. Thank you for your attention.
Thank you. James Patterson. James Patterson. Ali Panecker.
Good morning. My name is Ali Pasenka, and I'm a policy associate at the Sanibel Captiva Conservation Foundation, and I'm also recently a resident of Sanibel. But up until that point, I was a resident of Cape Coral my entire life. I grew up in Lee County, and honestly, I just absolutely love Sanibel and Captiva so much. The environment there is what inspired me to pursue the career path that I have, and I'm just extremely concerned about what this will do to our community and the environment. So I know that if this proposal goes through, it will harm the quality of life for people on Captiva, Sanibel, and in surrounding areas of Lee County. And I know this because I know what it's like to sit in the traffic every day, and I know how hard it is to find housing nearby my work, especially at an affordable price. And I want you to think about all the people that work on these islands but don't live there, so they live in surrounding areas of Lee County, and how much harder it will make their lives, and how much more difficult it will make it for island workers like myself. And I respectfully urge you to consider that when you're considering approving this. And I ask you to consider if this is a proposal you could stand by in 5, 10, 20, 50 years as it continues to impact people. And I want you to think about the hardworking, tax-paying citizens of Lee County who are the people that this is actually going to impact, not the people who are just passing through on vacation, but those of us that really live here, and it's honestly just going to make our lives so much harder, and I urge you to consider that, please. Thank you.
Thank you. Michael Polly. Michael. Lisa Ridden.
Good afternoon. My name is Lisa Reardon, and I believe I've been allotted 10 minutes. It's nice to see all of you this afternoon. I am the president of the Captiva Civic Association Board of Governors, CCA. At the HEX hearing, in addition to my own testimony, I submitted 84 signed and notarized written statements from individuals opposed to this rezoning application. CCA was founded in 1936. We are a membership organization of approximately 400 members, many of whom own property within South Seas or nearby in areas outside of South Seas. And our mission, CCA's mission statement, is very simple. It's the preservation of life, ambience, and environmental integrity of this unique barrier island community. You have all heard, and you all know, the reasons why the community strongly opposed the Captiva Code amendments you enacted 2 years ago, which led us to today's hearing. And that opposition, as you know, continues today. Opposition, I dare say, much stronger than you've seen regarding most of the other, if not all of the decisions you have made. For more than 2 years, the Captiva and Sanibel communities have done everything possible to have you understand why you shouldn't approve the increased density and building heights on Captiva. First, several of us personally met with each of you. Then you each received thousands of emails from residents, businesses, and Lee County visitors. Then we provided you with petitions signed by more than 13,000 people. Then you heard from the Sandcap Chamber of Commerce, the Captiva Community Panel, the Captiva Chapel by the Sea, the Sanibel City Council, SCCF, Ding Darling Wildlife Society, Bailey Matthews National Shell Museum, Crow, and the 12 South Seas Condo and Homeowners Associations and 8 timeshare associations. Then hundreds of residents testified at public hearings on the Land Development Code amendments and then on the plan amendments. Then 52 witnesses came to speak at the HEX hearing, and an additional 170 people submitted sworn statements there at the HEX explaining why this application should not be approved, pointing out public safety concerns from increased traffic, potential emergency evacuation problems, increased demands on police and fire departments, including our own fire chief stating the fire department does not have the ladder trucks or flow available to reach the taller buildings proposed in the application, as well as inadequate ability to add additional strain on the FGUA treatment plant, as well as so many more reasons. The Captiva and Sanibel community concerns have been completely ignored for more than 2 years. We were forced to file lawsuits and depended upon the courts. That was and is not our first choice. Our first choice is to have our elected representatives represent the people and the communities that elected them. To date, you have failed to do this, instead exempting South Seas from the long-standing regulations on our fragile barrier island and working in what seems to be to all a hand-in-glove relationship with one property owner to more than double the permitted density on his property or their property. Today's hearing is your last chance to stand up for us. Please understand that we know we've been lucky so far, but it's only a matter of time before there is a deadly consequence to not being able to get off the island in the event of an emergency, be it an evacuation due to a coming storm, a fire, or being delayed in getting to a hospital or doctor. Those of us who live on those islands know what it's like to try and get off during traffic in the normal season before this development gets approved and built. We've sat in 1 to 2 hour traffic trying to get off. Our practice is to go off island in the morning because you're going opposite traffic, and then come back in the afternoon, sometimes waiting hours in Fort Myers to avoid the traffic waiting to get on island each morning. You will be adding substantially to that. It is a fallacy that the traffic will be diminished as a result of this application. It is not possible that that would happen. People who come to South Seas come to visit not only South Seas, they come to visit Lee County, they come to visit Captiva, they come to visit Sanibel. You cannot convince anyone who lives here that someone visiting South Seas isn't going to want to go to the Bubble Room, isn't going to want to go see the Sanibel Lighthouse, isn't want to go to see the Mucky Duck. People around the country are waiting and anxiously on social media websites looking to see when our wonderful attractions are reopening. The Bubble Room opened 2 weeks ago. They have had hours-long waits for seating every single day since they've opened. That is before there is anyone additional coming to South Seas. People social media are constantly asking, when is the Mucky Duck going to reopen? When is Bailey's going to be able to reopen? People are asking about the Sanibel Lighthouse and going there. So I asked you to consider that. It is, as I said, a fallacy that these people who come to South Seas won't want to see these. They will push their baby strollers and ride their bicycles and ride in their golf carts out into the village of Captiva. That's what they've done for 50 years since that resort was built. A new owner is not going to stop them from doing that. That is their habit, that is their practice. So I ask you that before we have some sort of catastrophe, and to consider that putting more units, more cars, and more golf carts on Captiva now, after 3 hurricanes in 2 years, will put people's lives at risk. We are asking you to hear us. We live there. We know what it's like out there. And we are asking you to represent your constituents, to represent the people who voted for you, and we're asking you to deny this application. Thank you so much for your time.
Thank you. Drew Rock? Drew?
Need more resources, it's not like more restrooms. Keelan Bistro's open.
Thomas Salowski? Kelly Sloan? Holly Smith? Oh, sorry, come on up, Kelly. Didn't see you. My bad. Take your time.
Good afternoon. My name is Kelly Sloan, and I'm the Director of the Coastal Wildlife Department and the sea turtle permit holder for SECF. I've worked with sea turtles for 18 years now. The proposed rezoning will have significant impacts on sea turtles and other wildlife that is counter to the goals and objectives of the Lee Plan. 4 species of sea turtles are found swimming in the waters and nesting on the beaches immediately surrounding the land for which the rezoning is being sought, all of which are federally protected under the Endangered Species Act. Florida hosts the greatest number of nesting loggerheads in the world, and the decisions we make on our beaches directly influence the survival and recovery of these populations. According to Lee County and SECF data, lighting violations and disorientations occur annually in South Seas Resort. There is a clear pattern of violations in the resort, but even if there was perfect adherence to the window covering and lighting standards required by the Lee Plan, research demonstrates that red light at high intensity can still disorient hatchling sea turtles, and at very high intensities, the red light attracts hatchlings at the same rates as yellow and blue lights. The larger and taller buildings contained within the proposal will intensify the amount of ambient light, and the additional contribution to light pollution would be hugely detrimental. With about 30 to 80 nests typically laid on South Seas beaches each year, there are potential impacts to thousands of hatchlings. The Lee Plan is very clear in its goals that action should be taken to protect and improve the water quality, wildlife biodiversity, and critical habitats they rely on for their own sake and for the economic health of the county. Sea turtles are highly vulnerable species and need broad and intensive protection at all life stages to ensure their survival. This project jeopardizes the survival of sea turtles and sets a precedent that is unsustainable for the future of coastal wildlife in Southwest Florida. Thank you.
Thank you. Richard Sun King? Richard? Dana Sousa? Ken Suarez? Jared Kellen? Anthony Thompson? Andrea Titus? Ray Titus? Carol Witzel? Blair Watt? Michael Witt? Have I missed anybody that should have been able to testify? Any name? Seeing none, I'll close the participants.
Hi, I was here earlier, but I missed my call.
Sorry, by all means, come up, yep. Just
Hello,
state
my
your name
name.
for the record and how long you need.
Yes. My name is Audrey Albrecht. I'm a wildlife biologist with the Sanibel Captiva Conservation Foundation. I apologize for being late and missing my turn earlier. I was actually at South Seas conducting a shorebird survey and did get stuck in that traffic of tourists in the road on Captiva, as mentioned earlier. Thank you for allowing me to still have the opportunity to speak today. After reviewing the hearing examiner's recommendation document sent out on July 9th, I noticed once again very little mention of wildlife or impacts to wildlife. And while I do appreciate the steps taken by South Seas, such as new wildlife crossing signs and informational signs at the entrance to the beach addressing sea turtles and shorebirds, there's still some lacking. As someone who has spent the last decade conducting shorebird surveys on Captiva, I have concerns about the impacts of the rezoning. Excuse me, sorry, I was trying to catch my about the rezoning and the increased disturbance to our coastal wildlife that would come along with increased density and those changes to existing structure heights. Since I have limited time here today, I'll focus my comment on one aspect of my previous testimony, which is my concern regarding bird collisions and caused by reflectivity and new building heights. We know that collisions with buildings are one of the top anthropogenic causes of avian mortality, and while the conditions of LDC section 14-76 will be met for sea turtles, there are still no provisions to address reflectivity and daytime bird collisions. Goal 123 of the LEAD plan discusses managing coastal resources to maintain species diversity. South Seas is a birding hotspot with over 150 species documented on their own blog on their website, updated July 7th. They identify Captiva as a critical stopover for migratory birds. Knowing the importance of this location for wildlife, I would hope the county will recommend they reduce the reflectivity to decrease potential bird strikes. In the applicant's 48-hour letter prior to the last hearing, they attempted to combine turtles and birds into one group and only addressed the lighting issue. There's a lot of concerns for our wildlife and the health of our ecosystems that come along with increased density and intensity of use, including increased disturbance, degraded water quality, and collisions with structures or vehicles. Increased mortality of birds from any of those means I just mentioned have global implications. Migratory birds relying on Captiva as a nesting or migratory stopover come here from around the world. Just as we want to provide a safe and enjoyable experience for our human visitors, we need to offer the same consideration to our non-human visitors that rely on us. I believe that rezoning and increasing density is counter to the goals and objectives of the LEAD plan, and therefore I would hope the county would reject that proposal. Thank you so much for your time.
Thank you. Any other name or anyone else I missed? Bring it back up to the dais.
Yeah, the applicant would ask if we could have like 10 minutes break to get organized, if it's okay.
Sure, let's take a 10-minute break. That seems great. We could use a restroom break, I'm sure. Afternoon, if we could reconvene the zoning hearing.
Yes, sir, thank you. Neil Montgomery for the record. The first thing I'd like to have discussed is the FGUA plant. And I'm going to call 3 people, and they're going to cut to you quickly. Carl Baracco, David Brown, and Noah Valenstein. 1, the FGUA plant is not on South Seas property, so it's not part of this rezoning. 2, Mr. Evans said that his testimony was not rebutted. It most definitely was. 3, we object to him as a policy person, not being an expert in engineering hydrology and not qualified to render his decisions and opinions. With that, Mr. Baracco.
Good afternoon, Mr. Chairman, Commissioners. For the record, Carl Baracco, I'm a professional engineer with Baracco & Associates. I'm going to address some of the things that you heard today, but I might bounce around a little bit because I'm going to try to get in order as I heard them. I'm going to first start with the utility capacity. During the hearing examiner presentation and this morning, I heard confusion and misinformation regarding how the flows and demands are established. So I'm going to try to clear that up for you this morning. I'm going to try to keep it very
Speak up a little bit, Carl.
Yes, okay, let me know if I don't go loud enough.
And I don't know if IT can pull the volume up too. We had some people say earlier it was low volume from the speakers and the audience of that mic, so hopefully the IT can bring that up a little bit too.
It's a new mic.
Thank you.
Go ahead.
Okay, so we have letters of availability from IWA, Island Water Association, and FGUA. IWA has confirmed they have 87,000 gallons per day available for this project. FGUA has confirmed they have 117,880 gallons per day. That's clear, and it really is undisputed. It's in writing from each of the utilities. But I think where the misinformation and confusion comes from is how we estimate those new demands on our water system and sanitary system. For instance, this morning we heard we should be considering the difference between hotels, condominiums, 1-bedroom, 2-bedroom, and 3-bedroom condominiums, and that's not how we do our estimates. We have procedures in place with B County Utilities, IWA, and FGUA as to how we come up with those estimates. So, understanding all that, I'm just trying to be clear and concise with two statements. I think if we just say that the net estimated new potable water demand resulting from this approval will be at 87,000 gallons per day, which IWA has capacity for. Similarly, with sanitary sewer, the net increase in sanitary flows to the treatment plant resulting from this approval will be at 117,880 gallons per day. We know that capacity is available. So in summary, in my professional opinion, both IWA and FGUA have confirmed that there is utility capacity for the net increase in potable water demands and sanitary sewer flows resulting from today's action. Next, I heard the second speaker talk about pollution leaving the internal roadway. But we also heard from Ms. Crespo that the internal traffic is expected to decrease. Hence, we can expect the pollutants leaving the internal pavement to decrease. But even beyond that, it's important to know that the existing water management system serving South Seas is a full retention system, one of the most efficient water management treatment systems we can introduce. That's not only historic, it's in our most recent South Florida Water Management Permit, and that is the system is full retention. Beyond that, we went a step further working with staff, and there's condition 10 in the documents, and that is if for any reason a positive discharge is added so that we no longer have full retention, when that goes through the permitting process through the South Florida Water Management District and Lee County, a water quality treatment program will be added, because at that point we would have water discharging directly to the tidal water so we could collect it and sample it. Right now in the full retention system, all the runoff is directed to the internal system where it leaves either through evapotranspiration or percolation and has no direct discharge to tidal water. With regard to the FGUA plant, the plant really isn't subject to what we're looking at today. We know it has capacity, but I will tell you that I am familiar with one violation, and we heard about several violations, and I believe it's the most recent violation, and that happened in the last few years. FGUA had a metal storage tank, developed a rust hole. That rust hole started leaking as soon as FGUA determined that there was a leak. They self-reported that to the FDP, and they made the correction. So everything I've looked at regarding FGUA and the treatment plant is proceeding fine, and that is subject to FDP review and approval. Ms. Berkey talked about the function of the internal roadway. That system, as we said earlier, will have reduced traffic internal. Beyond that, That system has been functioning historically, as will continue to function. And added on even to that, at staff's suggestion, the proposal includes now a signing and marking program, which will be implemented with the development order through the process. So there's an additional improvement there with the internal system. That's all I have. If you have any questions on what I went over or anything else, I'd be happy to address them.
Any questions from the commissioners?
Thank you for clarification.
No, thank you for your testimony.
Good afternoon. I'm David Brown. I'm the National Practice Lead in Hydrogeology for Respect, and I'm here to talk a little bit more about water quality. I've been practicing as a professional in Southwest Florida for almost 40 years, and most of that work has involved water quality analysis, collection of data, and so forth and so on. First off, the wastewater plant is only issued a permit every 5 years. Permit is up next year, and it must meet the conditions of issuance each time that permit is issued. So there's a very stringent criteria that they have to go through to not only operate that plant, but to renew the permit. As required by the permit, FGUA tests monthly for total phosphorus and total nitrogen. So there's an extensive amount of testing that goes on the reclaimed water, as well as a number of other parameters, including chlorine. The water is chlorinated prior to it being used. The water from the plant itself then goes to a storage tank. There's a water use permit that's issued to South Seas that has groundwater wells. One of the groundwater wells then helps to supplement that water in the tank, where the reclaimed water is stored prior to be used for irrigation. I went back and reviewed some of the data from the South Florida Water Management District, also in the FDEP Oculus database. And on average, about 20% of the reclaimed water is supplemented with groundwater. So it's further diluted in this tank with the use of groundwater prior to it even being used for irrigation. Once it gets used for irrigation, as Carl just said, the facility is a zero discharge facility for stormwater. The only way for stormwater to escape is through the stormwater ponds, through evaporation or percolation, okay? Then the DEP permit requires there's 3 monitor wells that are on site. One is a compliance well that looks down gradient from the use of reclaimed water. One well is an intermediate well. It's in the area where reclaimed water is used. And one is a background or upgradient monitor well. They haven't had any violations of water quality. I looked at that data for almost 2 years. And when I looked at the nutrient data in those monitor wells, it basically meets advanced wastewater treatment with nitrogen being consistently below 3 milligrams per liter. So there's no violations of groundwater quality as well from the use of reclaimed water, and it's heavily monitored, as I said, through the permit. In addition to this monitoring that I've talked about, that's a requirement of the permit, the zoning hearing officer implemented a golf course management plan through some of the conditions that requires an integrated pest management and nutrient management plans that must be implemented, okay? As well as best management plans through golf course and greens for the greenskeeper and the golf course maintenance operator. But that adds another level of water quality monitoring for the outfalls, which are the stormwater ponds, which those have to be monitored again for nutrients, both in the dry season and in the wet season. So we have a multi-layered system of monitoring water quality and providing additional assurance that water quality standards are being met and that this facility and the use of reclaimed water is not impacting the water resources surrounding the island of Captiva. Thank you.
Thank you.
Thank you. For the record, Noah Valenstein. Touching on just a couple other points regarding the wastewater treatment plant. As just mentioned, the Florida Department of Environmental Protection has authority over wastewater treatment plants in Florida under Chapter 403 of the Florida statutes. DEP provides strong permitting and compliance oversight, as well as programs to assist with making improvements through grants. I know the public comment referred, I think from Sanibel Captiva Conservation Foundation, referred to a warning letter from DEP to FGUA dated February 5th of 2025. We looked at that, nothing the warning letter impact FGUA's determination of plant capacity or availability. I'll also mention our firm did a review of the wastewater treatment plants on the island, which would be the Sanibel Donuts plant, as well as FGUA, to sort of look at the DEP's enforcement and oversight of wastewater and see how that was occurring on the island. I'll mention that just a day later, on February 3rd, 2025, DEP issued a compliance letter to Sanibel's Donex plant covering 6 separate spills from September to December of 2024. And over that time period of 2023 to 2025, there appeared to be about 30 reported overflow events, 6 of which were from FGOA and 24 were associated with the Donex wastewater treatment plant. I'll mention the fact that you have that public record that you can go online and look at how the department's engaging shows that there's close oversight to make sure that any issues are addressed, fixed, and where there are opportunities to improve and invest, the department, if they deem that appropriate, will do so. And that leads me to my last comment, which is the department issued in 2023 a grant for $7 million to FGOA for improvements at the South Seas Island Resort FGOA plant to further improve the environmental friendliness of that plant, reduce nutrients, and improve that site. And in fact, there's an executed grant agreement for that already for the $7 million for that plant. Thank you very much, Commissioners.
Thank you.
And I would note that everyone else on the island is on a septic tank, so some folks today suggested that this is going to set a precedent. It can't, because this is the only property that's on central wastewater treatment. The rest of the island isn't. You heard a lot about traffic. I would note that Drew Rourke was the traffic consultant for CCA at the hearing examiner. I believe that he had a flawed report, but I just want Mr. Treese to just briefly touch on transportation because it was reviewed. And Mr. Treese had the opportunity to go out and redo some numbers, so I want you to know that.
Good afternoon, Commissioners. Ted Treese, just reiterating some comments from the hearing and then based on testimony this morning. We did prepare the traffic analysis consistent with the administrative code requirements of the county. We did update, as Neil said, during the process with new traffic data that we collected on the island during that analysis. And those results are all part of the record, and staff did agree with our analysis that was submitted as part of the record. We did rebut Mr. Rourke's testimony during the hearing. His analysis relied on some incorrect data that was in the concurrency report. DOT staff did acknowledge that there was an error in that data. That's since been corrected with the new report, but so all that information is part of the record, and the analysis was conducted pursuant to the county requirements, and staff did accept it. Thank you.
May I ask before you step away? So it is your professional opinion that what's written here in the record, that traffic would actually be reduced by eliminating some of these public, like the public marina and other public activities out there, traffic would be reduced then?
That's correct. Okay. Just one example, one of the uses that has been eliminated was the sightseeing tours that were open to the public that launched from the marina, and that use has been eliminated and removed. So most of those trips came from outside the resort. So that's just one evidence.
So does your report that you put together contemplate maybe the new employees that would be hired to work out on South Seas and what their impact on traffic would be?
Yes.
And so even with all the net increases potentially from new employees or more guests, eliminating the public access to the South Seas, the net effect is actually less traffic then?
That's correct.
Okay, interesting.
Thank you.
I have a question. Ted? Yeah. Sorry. Do you factor in, obviously, the community out there has changed the last 3 years. I mean, there's a lot of businesses that don't exist anymore. I mean, if you drive through Sanibel and Captiva, obviously, we've lost a lot of businesses that have not came back and may never come back. Does that look at that, too, historically, what the traffic was, say, 5 years ago? Because, like most of the things we heard today, the testimony was not accurate because they talk about current conditions. Right. We're looking at this the future based upon the application here. They're talking about current conditions. Obviously, I think the complaint I get every day, obviously, there's no roundabout at Periwinkle on the bridge, but that's another issue for the city of Sanibel. But the point is, traffic-wise, the conditions we're talking about now is the seasonal, it's current now, without this new impact. But so you did factor into the existing places now, like the different restaurants and stuff in Mad Hatter and all those cottages along Captiva that are gone, so that you don't have the service workers there, you don't have the customers going there, less traffic goes to that too? And you looked at this 5 years ago, or is this more of a scope now?
Well, what we did is we looked at existing conditions, but then we project out to the future for the build-out analysis. So we do look into the future. We do increase traffic based on historical demands. The historical traffic growth has decreased over the last 10 years going on to the islands. So we took that into account, but there was some increase of traffic demand in the background conditions before we added our trips on from this project.
Okay, thank you.
Yes.
Can I follow up?
Yeah.
So your statement was the last 10 years, the traffic has decreased?
Yes.
Going out on the Sanibel?
Traffic has not decreased. The rate of growth of that traffic has decreased. So the traffic, I didn't say the traffic decreased, but the actual annual growth rate of traffic has decreased.
How many employees do you, your projections indicate will be working at the facility?
That would be an answer for someone from someone else.
I just thought in your calculations with traffic, you didn't understand how many people.
But let me answer that question this way. There is a condition, I believe it's number 18, imposed by the hearing examiner, that requires a shuttle for employees in 3 different locations. And there was testimony about the significant usage of the shuttle to accommodate employees.
And I will note, our traffic analysis didn't take into account that shuttle employee reduction because we looked at the normal trip generation from a hotel unit, which does account for employee trips. So anything that South Sea does in terms of shuttles for their employees will further reduce the trip generation that we estimated in our analysis.
But you don't have a number of people?
Someone from South Seas can provide that.
Okay, and what type of demands is South Seas doing for employees to be on the shuttle? Is it mandatory? Is it optional? Is it?
Thank you,
Okay,
Mr.
I'll look forward to that person. Thank you.
Okay. I have a question maybe for our county attorney. We're hearing a lot today about traffic, and obviously we know this, we talk about this a lot of the zoning cases, and somebody's watching up north right now may not know what happened in 2012, I believe. The Florida state legislators made some changes about how we govern and see zoning cases, what can be denied or not denied based upon traffic. Michael, can you talk about that real quick?
As you've heard many times before, the fact that a development creates additional traffic is not sufficient basis to deny a zoning request. We no longer have traffic concurrency, so that's not an issue as far as the road.
We've had this discussion many times. Many years ago, I remember we brought up trying to get Leitram, for example, access to Sanibel and those islands to get more accessible, to reduce traffic, to be more, so to reduce that traffic, but that was obviously turned down in the year. So we heard some conversation today and testimony. Maybe that was something that could be looked at in the future, so thank you. Go ahead, Neil.
Yes, the next issue I want to talk about is hurricane evacuation. The applicant provided an expert who did an analysis in accordance with the state rule. The opposition had a hurricane expert who wasn't here today, but he didn't actually submit his report to the hearing examiner. He merely stated on the record, I made one change to that report, but he didn't give her the report. The report he made a change to was the one he submitted in the DOA proceedings when they challenged the ordinance. And so same people testified, Mr. Alexander and Mr. Trescott, and the administrative law judge did not accept Mr. Alexander's testimony and did accept Mr. Trescott's testimony. So nothing really changed in both those proceedings. Not accept Mr. Alexander's testimony and did accept Mr. Trescott's testimony. So nothing really changed in both those proceedings.
To the community, so it is a well-liked system. As far as
what's your assumptions on the usage of that?
we expect.
I'm sure in your traffic analysis you put that in factor, no?
Well, I think I can't speak to how his analysis was done to that. I can speak to our participation with it. We're somewhere around 20% capture for targeted employees. There's certain employees that are not going to use that because that doesn't work with their work schedules, or like for me, I have to drive out because I don't have an 8-hour shift and I can't fall into that shuttle window. So 20 to 25% capture for those hourly team members that fall into that use of that shuttle, that fall into those.
Okay, thank you.
Of course. As far as emergency management plan, I think it's important to understand we have a great plan. It's not only built for our guests to get our guests off the resort, but it's also built for our Lee County resident employees to get off and take care of their families, and if that is going to impede in there. So I think that's important to understand. The plan's all laid out. We have documentation that was presented to the HECS, and I'm sure all of you have. We have not only done that plan and updated every year in March because things change, as somebody mentioned earlier, it's point proven. I've been here for 15 years. Hurricane Irma, Ian, Milton, all evacuations of all team members and all guests are done 24 to 48 hours prior to storm impact. So a lot of the windows that were brought up during these things are in that shorter window, and we're gone. We wrap up and leave because we need to make sure that our families can take care of their own and get out of Lee County if that's what's required or in their specific areas. So we're not just focused on the guests. The other point I would make on that is evacuating residents and evacuating guests are two different things. Yeah, they're both critically important, but guests we can mandate. We run a business. We are closing in 2 days because of the storm warning or whatever that window is, depending on the storm. Storms are always different. And we mandate. We work with those guests and get them out of the resort to lower that, because we can't have guests around if we are cleaning up and securing the property for storms. So we take it very seriously. Thank you.
And one thing I want to point out in regards to the hurricane situation, the county does work with South Seas to do staging on their properties so that they can be ready after the storm. And in fact, Sean and his people worked with the county to help clear the roads. So they're part of the solution and not part of the problem. The last two witnesses, Ms. Sloan and Aubrey, talked about turtles and birds. We've addressed those, but Kathy Olson is briefly going to respond to that.
Good afternoon, Commissioners. The current conditions on this project for sea turtle glass is above and beyond what is stated in the code, as is the same with shorebirds. So the HECS has put conditions on this project that goes above and beyond the code.
Nice to meet you again, Kathy. Thank you.
One of the things you heard over and over today, and I indicated at the beginning that you would hear it, is that 1973 zoning resolution limited hotel units and residential density to 912 units. It didn't say that this morning, and it still doesn't say that. And the density is consistent with the League plan, and hotel units are not density, but that's a planning question, so I'd like Alexa Crespo to address the historic argument and the density intensity.
Alexis Crespo with RBI. I agree with the statements that Neil just indicated on the record, that the 1973 ordinance does address hotel ambiguous with dwelling units. However, we are being reviewed today under your current LEED plan, under your current land development code. Your chapter 34 very clearly indicates that hotel rooms, in this case, as well as across Lee County, are intensity. We do have to have that intensity, the scope, scale, height of those hotel buildings be evaluated against your LEED plan. Are they compatible? Do they meet all the different policies addressing commercial intensity like hotels? And we have met that burden of proof through our application materials. Your staff is in agreement, as well as your hearing examiner in agreement with those items. There was also a lot of mention that we can never ask for more. I think the hearing examiner in the very first page of her recommendation does an excellent job of stating that the ADD does not prohibit us from seeking an amendment through the public hearing process, or in this case, a rezoning to a PD zoning district. We are allowed by your private property rights elements to make that request. We must be consistent with your criteria. We must be consistent with your lead plan, which we are all in agreement. This application meets those criteria. Thank you.
Thank you.
I do want to, you heard all the attorneys talk about the fact that they think they should be a party. It's my submission that the county complied with Chapter 34, AC 2-6, which is the administrative code that applies to the hearing examiner, and that we've complied with AC 2-7, which is the code that applies to you folks. I would, rather than take my opinion, I'd ask if you have a question or concern about whether we followed the codes correctly, that Mr. Jacob has been involved in that. They have inquired of him, and he has responded. So I think that he can address that. I would note that all of the attorneys didn't say anything new today that they didn't say before. I did not cross-examine or wasn't allowed to extensively cross-examine them because under your administrative code, what attorneys say is not evidence. It's not competent substantial evidence. It's argument. And in fact, I wasn't allowed to ask Mr. Bell any questions because it was determined that everything he said was legal argument and not evidence. So you can't change or deviate from the hearing examiner's recommendation based on argument because it's not competent substantial evidence. What you didn't say today were any of the experts that said that there was a mistake or fact of law in the record. So I would submit, based on 9 days of hearing where the public was not stopped and allowed to talk for hours, some of them, Mr. Grosso talked for 3+ hours, so they were not denied due process. They had extensive due process, and I would submit they have more due process than they would in any of your other local jurisdictions and other places around the state. And I would submit that the request for a motion to stay is inappropriate and not consistent with the law or with your code, and it's just another effort to try to stop this developer who's been trying very hard to rebuild their resort since September, I won't remember the date, of 2022, but it's been a long time and a lot of investment to finally get to this point. And I would hope that the hard work and that long list of experts that we had testify is recognized and that the hearing examiner went, in my opinion, above and beyond in letting them express their thoughts, opinions, but still recommended approval, that there is no basis not to uphold the staff and the hearing examiner and to ask you to please approve it. Thank you.
I have 2 follow-up questions. I apologize. One is for Carl, please. Just want to make sure I wrote the numbers down correctly. You'd indicated that potable water is 87,000 gallons per day?
Yes.
Okay, and you'd indicated that wastewater is 117,880?
Yes.
Okay. The staff report that was submitted on page 524 indicates it's 187,457 gallons. How do you come up with that number? How do you dispute your 117 with the staff report of 187? Page 524 it is.
I'd have to look at it. And are you speaking of water or wastewater?
Huh?
Water or wastewater?
Wastewater.
You have that page?
Page 524 is in the report. I can go downstairs and get it printed if you want.
What page is that again?
524? Read the makeup if you want. If it helps, the title of the report says South Seas Water and Sewer Demand Analysis.
That's an outdated,
Huh?
that was an outdated analysis.
outdated?
An older, yes, sir.
Did you replace it with a revised? Because that's what I'm looking at.
The most recent letter from IWA was in 2025. It was after that, and it was based upon the final units that are in the
Yeah,
program.
my only struggle I'm having is the staff report that's in the report that I read. There's nothing that revises it. It says 187,000 gallons, which is 70,000 more gallons.
As I recall, that's an additional analysis that we were asked to do that looked at everything in total. So what you're referring to is everything in total. What I'm referring to are just the net new.
Okay. The concern I have, just to follow up where I'm going, the concern I had is obviously having governed there for 13 years, we had a lot of issues with different bacterial matters, beaches being closed, backups. So obviously, when South Seas had high demands, we had many issues. We were fined, and FGA was fined numerous times for that. So when I'm hearing about additional capacity, I'm hearing about this. Analysis is correct or not correct because there were issues in the past when they had high capacity. So the concern would be, why wouldn't we have the same? And when I have contradicting numbers, I'm an accountant.
Okay,
It contradicts
and as we're talking about this, my recollection is coming back to me. The analysis that you're looking at is basically a more overall analysis. So it was existing and what we're looking at. What I'm talking about as far as future capacity, it's only what this zoning would add in and allow in addition to what's there today. So it's just a net increase. So the net increase is what we know we have capacity for. The analysis you're referring to, there are different numbers because that was another approach looking at everything in total.
Yeah, I just read the report, that's all.
Okay.
Thank you. Anybody from FGA here? No?
No, they didn't testify.
I just, no problem, thank you.
Chairman, can I ask a few questions, follow up?
Sure.
Sure. So we just heard basically for over 3 hours about how negative this is going to be. But one of the things I wanted to ask is, the LEED plan economic element encourages retention and expansion of existing businesses. And I know this is a quasi-judicial format, but I guess that must mean it's partly political, right? And so none of us ran on the idea that we would close down businesses or not create jobs. I think everybody said we're going to try to grow this economy and create jobs, especially in the wake of Hurricane Ian, such a devastating storm. So I guess the question I wanted to ask the applicant was, could somebody talk about the economic impacts of this project? And I mean, we've already heard potentially 800 associates are going to work out there, but anybody speak to the economic element of our goals and LEED plan there?
And he just testified on economics after the hearing examiner did this slide.
Thank you, Mr. McGowan. I was going to ask the same question. We heard about how this would be detrimental to other jobs that's currently existing, but there's obviously jobs in the South Seas too that we should be looking at too. So not just the current jobs that people are trying to, get rid of now. So, thank you.
Absolutely. For the record, Greg Spencer, I'm the president of South Seas. Yeah, I did testify to that at the hearing examiner, and I think that's a great question. Let me answer that, but I want to answer first by talking about what we lost. We took a $400 million loss when the hurricane hit. We lost 24 buildings. So when we start looking at capacity, all that got destroyed, and that's what we're trying to replace. We lost our hotel keys. So we literally went from having close to 400 employees direct down to 45. We kept them employed. We didn't use third-party companies that all swoop in after a hurricane. We used our own employees to get the resort back online. So the lowest we went down to was 46. We kept them employed through the entire window. But talking about the future, that's what we're talking about. We're talking about making close to $1 billion investment in Lee County. And with that comes jobs. We talked about 800 direct jobs, so going from 400 to 800 direct jobs. We've talked about 1,600 construction jobs that are going to be sustained over a 6 to 8 year window, depending upon appeals, et cetera. And I think that's the important thing, and it's the indirect jobs that get created throughout the community. So it's the 800 direct, and I believe our payroll is over $100 million a year in just payroll just for our employees, right? And that doesn't include the knock-on payroll expansion from all the other folks. So I think that's an excellent question. The other thing that we really haven't talked about is where the resort was when we bought it. When we bought it, we did a survey, a quality survey, and there's a national system called Net Promoter Scores, and typical luxury is around 76. My company, Timbers, runs anywhere in the high 80s to low 90s. South Seas Resort was a negative 30. So the scoring goes from negative 100 to positive 100. That means 3 out of 10 people were not coming back, right? And that was the issue, is that the resort, even before the hurricane, was on a downward trend as far as the rates you could charge, and just the occupancy. And I think that's something that when we saw it as an opportunity to really try to improve not just the baseline resort, hopefully expand it and add it. The other thing I would just add is the consumer's ever changing. I've been going to Sanibel and Captiva since I was 9 years old. So for 46 years, I've been out there, and it was a great resort. I appreciated Commissioner Rain pointing out Al Timbrook. I stayed in very close touch with Al, and frankly, South Seas were the ones that paid for the Celebration of Life because it was well earned. And back in the 70s and 80s, that was a great resort. That was the standard. But that is not the standard now. If you go to any of the other resorts, Marco Island, even in your own backyard, the Hyatt Coconut Point, they are adding amenities like water parks and different things. And that is what the consumer is asking for right now. So really, I would envision this as not just helping us recover from the storm, but it's really setting the base for the next, 50 years. I hope there's a kid that's 9 years old riding his bike around today that comes back and says, oh, I wouldn't have done what, the Timbers guys did. I would have done something different. That's great. That's the evolution. And just for the record, there weren't 20,000 square foot homes when I used to go down here when I was 9 or 10 years old. There were 1,200 square foot homes. Those have been tore down. They've been built. Even some of the applicants that spoke here or that were represented here have pretty massive homes. So there's been a constant evolution and change happening in the island. And look, we operate at a very high luxury level, and we have to deliver the experience, right? And so we want water quality. We want the nature. We want that. So I think all that does go into the economic viability, not just of the resort, but of the entire community.
Okay. Thanks. That hit on what I was looking for. Thank you.
I have a question. Ray, you might be able to answer this question. I heard some, I guess you would call it argument of testimony from one of the attorneys that are saying that with extra rooms, extra density, the tenants are going to have to leave to find amenities. To me, amenities would be restaurants, food, recreational stuff. I can't see why anybody would have to leave South Seas, for example, when you could go outside the gate and go to Boca Key Lime Beach, all the restaurants, to drive. I think that he actually used the term, go to Sanibel and create more traffic. I can't see why they would drive 20 miles per hour to go to Sanibel to find a open restaurant, which is very few there now. But would there be a lack of amenities? Or you increase the amenities, the services? We heard today, obviously, from a lot of the testimony today, that people have to wait for hours, obviously, at the ballroom. So it looks like we need more restaurants out there, more amenities. So are you looking to increase that commercial element too?
Absolutely, Commissioner. And we are pouring right now over $60 million in new amenities. That's in addition to the $50 million we spent cleaning up and repairing the existing restaurants. Look, we have no problem with folks using our amenities, but you're going to pay for it. What we're not going to do is let you use our amenities for free. And I use the analogy, some folks have gotten up there and said, well, I used to get access. Everything they got access to got destroyed by Hurricane Ian. We built it back. And there's some just philosophical differences of opinions of what an agreement says. We're going to let a judge determine that. But what has been asked and what I think has been angled for is somehow getting free access. It even came up at the hearing examiner. The gentleman that testified today for HGV got up there and she said, well, wait a minute, are you basically saying these folks should get access for free? So I don't have any problem with folks using our amenities, but you're going to pay for it. What we're not going to do is we're not going to let our competitor who came up here and spoke to compete against us from a rental perspective, use our amenities for free, and we're not getting any fees off of it.
That's just fundamentally un-American. So I think we invite everybody to participate in our rental program. We invite everybody to participate. If you don't want to rent your unit, you can buy a membership. We'll gladly sell you a membership. We're capitalists. That is what we're here to do. We don't have a problem doing that. But what we're not going to do is let people use our amenities for free. And that's really what, there is a lot of sensitivity and disagreement coming down.
Really curious, because I was concerned about the amenities, because I personally just stayed last month for a conference at the JW Marriott down on Marco Island, and I didn't use the facilities, but I know if you use the pool 50 feet away in that adult section of the JW during the conference, you can't use it because you're not staying in that side of the hotel. So if that happens, that's a standard throughout the world now in resorts like this. So I was just curious why they would think they would leave that area to go somewhere else.
There's plenty of golf communities.
Destination to go to.
Yeah, there's plenty of golf communities out there where you choose not to be a member of that club. It's a free country. You don't have to be a member of that club. But if you want to play golf, or if you want to get food and beverage, if you want to use those amenities, you have to pay for it. And that's where there's definitely, some tension and I understand. I'd like to get stuff for free too. I'd like to get the construction for free, but we had to build it. And that's all we're asking for, is for people to be a member in our program and pay for it.
We just did that ourselves as a board yesterday, which is the northern part of Lee County, not Captiva, is Boca Grande. We actually itemized that parking situation based upon visitors and how they're staying there and who their guests are. So, okay, thank you.
Any further questions? Thank you.
Mr. Chairman, if nobody has any further questions, then I'd like to go ahead and make a motion to approve the hearing examiner's recommendation.
Second.
All right. I have a motion and a second on the floor. Commissioner Greenwell, any thoughts, comments?
Yes. Yes. Thank you, Chairman. It's been a long time sitting here being quiet. So thanks for the opportunity. I see no reason to against. I think we are a growing community still, and I think we have an opportunity to do something special for Lee County here. I see no reason to overturn the hearing examiner. So I obviously am for the project.
Great. Just a couple things for the record. Having governed in Sanibel for 13 years, there were numerous violations of flow in excess of capacity, a lot of bacteria in the water. I'm struggling with the conversation with wastewater, struggling with the report that was in here, and for that reason, I can't move forward with this. I oppose this application. I'm happy for the whole economic impact for the island. I just think the wastewater, I'm struggling with that component, so I will be a no.
Chairman, if I may just put a comment or two on the record, I won't go for 24 minutes. I'm joking. We can laugh a little bit. No, but obviously I made the motion, and I want to explain why real quick, because this is a hard job right here to do zoning. In zoning, you've got to make a legal decision, a decision that is legally sound, but you've also got to convey to the people in the room that you care about what they said in their testimony as well, because as we said, it's quasi-judicial, which means it's probably partly political. So I want the people to know that I absolutely do hear what you say and take into consideration what you say, but at the end of the day, I didn't find the evidence to overturn what the hearing examiner concluded. I just didn't, I didn't find an error in her recommendation. And so that's why I made the motion for approval, subject to the conditions and deviations, obviously, that are written in there. But, from just a personal standpoint, as somebody who was born and raised here, grew up here, I can tell you, not everything is the same today as it was in 1973. First of all, I wasn't here in 1973. I was born in 80.
Really?
But
you've got to keep rubbing that in.
You really got to go there? Like, really? Okay.
But it was clearly, it was articulated that the market wanted something different in 1973, and it was in the 70s and 80s, the cream of the crop, just top, resort. But clearly we heard the testimony again, even today, that the market didn't really want it anymore. The net promoter scores were down. And so that tells you that the whole reason why America has the ability to amend things. Even the great Constitution of the United States of America has a process to be amended. The ADD, while I think could certainly be respected, also should have a process to be amended if the market and conditions determine that that's necessary. And so, I think there's an opportunity here to to allow something that I think is compatible with the way the rest of Captiva operates to be able to respond to what the market also wants. I look at Captiva today, and I imagine it's a lot different today than it was in 1973 as well. That's why I kind of asked the questions about, you know, the timeshare owners. I mean, so you got 6,000 people who own a fractional piece, like maybe 1 week potentially, of Captiva at the South Seas Resort. You got all the condos that, you know, we had an attorney from a property management company who does a rental program testify. So, I mean, clearly they're using something like a hotel. And then, you know, many of the actual homes, you know, Airbnb, VRBO, they didn't exist in 1973, but they certainly exist today. And so many of these homes are being used that way on Captiva. And so I don't find what's going to happen here at a resort that was already a resort to be incompatible with the way the rest of the island is used as well. And then finally, the last thing I wanted to say was just, you know, some of the testimony today made it sound like it's a negative thing that the guests of the resort may visit restaurants on Sanibel and Captiva. Truthfully, gentlemen, we have been fighting very hard to get people to go back and visit those restaurants on Captiva and Sanibel. In fact, we've waived bridge tolls for weekends. We've put on events like the Island Hopper Singer-Songwriter Festival. So I just disagree that that's a bad thing. I think that's a good thing. And so, you know, that's kind of the basis for how I arrived at my decision.
Yeah, can I add, since I second it, and Commissioner, don't forget, we also sponsored the Chamber the last few years because we make sure they keep their doors open to get people to come back to the island. Yeah, Commissioner Hammond, thanks for bringing it up, and I will obviously recognize, yes, you weren't here in 1970, but unfortunately I was born and raised here. Myself and my colleague here, Commissioner Greenwell, we've been here since 1963, right, Mike? So the point is, you know, we're here today because of what happened on September 30th, 2022. None of us here on the Board of County Commissioners ever thought on September 29th would be sitting here and ask these questions. We're here today because we are the receiving government agencies for this application of this rebuild. None of us here wanted this to happen. So I know there's going to be some people out there saying this is all our fault or whatever, but we are the receiver government authority that actually has to receive this application to give us approval for this. And me, just like Commissioner Hamm and my other colleagues that's been here all our lives, we try to protect Lee County. That's why 70% of Sanibel, I believe, is still in conservation. I don't think we've ever voted against a conservation piece throughout Lee County. So we're constantly trying to preserve the area. It's just hard for me to sit here and say, like you said, that this building, which is still shorter than buildings currently on Sanibel and other parts of the county, other Barrier Islands, is going to be detrimental to bird life or the water quality or anything else. And that's why it's unfortunate this happened, this storm. But we have to move forward. We have to understand that in 1970 or 73, when it was, this was built, things change. It's unfortunate, but things do change, and we have to follow. We, as the board, has to follow the law, and that's why I second the motion for that. So thank you.
Hey, Commissioners, I agree with your comments about all we've done economically, and I want South Seas to be as successful as humanly possible. I did for so many years as mayor there, so it was a frequent situation, which I hope we never have. But those are my comments for the record. With that in mind, the motion carries 3-1, and we'll move on to, sorry? We voted? Commissioner Hammond said yes. Commissioner Pendergrass said yes. Commissioner Greenwell said yes. Commissioner Wayne said no. 3-1. This matter is concluded. Want to take a 5-minute break before we go to the other two cases? Or?
I'm good to go.
Huh?
Can we get rid?
Okay, all right, then we won't.
May take 2 minutes.
All
We
right.
can just let the room clear.
We'll wait a few minutes to let the gallery empty. Good luck. Staff, if you want to introduce DCI 2024.
Good afternoon.
Thank you.
My name is Cam Mohammed, zoning planner, zoning section of Lee County's community development. The case before you today is 94 4th Street, a CPD rezoning titled DCI 2024-00024. The request is to rezone approximately 0.66 acres of currently zoned two-family conservation district, TFC2, to the commercial plan development, CPD, zoning district to allow a maximum of 1,016 square feet of commercial uses. The property is located within the Page Park Community Plan area. The future land use of the property is central urban. The property is currently zoned TFC2, two-family conservation. It is also located within the mixed-use overlay. And this is the master concept plan of the site as proposed commercial plan development. Staff and the applicant are available for any questions.
Any questions for staff?
No. Mr. Chairman, I'll move approval, subject to conditions and deviations of the hearing examiner recommendation.
Second.
I have a motion and a second on the floor. I don't have any participants. Anyone object? No objections? Motion carries unanimously. Let's go to case 2.
For the record, Adam Mendez, Principal Planner with Community Development Zoning Section.
Chairman, before we start the case, I need to abstain from voting on the case. I need to read in. I am abstaining from voting on DC 2024-00023 due to family member hired as general contractor of the project. I will file the conflict of interest form 8B with the minutes office.
Thank you, Commissioner.
I'm abstaining. Yes, sir.
Thank you. Anything else we need, County Attorney?
No, sir, that's it.
Huh?
That's it.
Thank you. Proceed.
Thank you. Well, as you heard from Commissioner Greenwell, the case number, this is in reference to JBRA CPD. This is a CPD rezoning. The subject property is located at 19260 San Carlos Boulevard. It's in the San Carlos Island Community Plan area. You see the aerial here. It's located in the urban community future land use category. It's approximately just over a quarter acre, 0.26 acres. The property is currently zoned commercial C1 conventionally. The request is to rezone the subject property to the Commercial Plan Development District to permit or to repurpose an existing 2,840 square foot building as a package store. There's also retention of a short list of neighborhood commercial uses. The hearing examiner's recommendation before you is approval with conditions, and there were 3 participants of record. Staff and the applicant are available for any questions.
Any questions?
No.
Call the participants up. Christy Hennessy? Christy here? No? Stan Schrouder? No? John Zumbeck? John Zumbeck? No. I have no participants.
Mr. Chairman, I'll move approval of the hearing examiner recommendation, approval subject to conditions and deviations.
I'll second that. I have a motion, a second. Any other discussion? Anyone opposed? Seeing none, motion carries unanimously. Thank you. We'll conclude for today. Thank you all.